May be permitted to pick up the petition with certain observation.
Beg pardon, my lord. Beg pardon, my lord.
Your time permission. Item 67. Can it be taken up at 2 p.m.?
I think I'll take it up at 2 o'clock only because it may not reach 7.
Pardon, my lord.
Pardon to mention, my lord. My NBW issue against the present petition on respect to 138 NIF, my lord.
Give it NBW. Petition.
And another 3 madam question of FIR, my lord.
Watching of FIR, you give the NBW first, you give.
My lord.
Watching of FIR.
Pardon to mention, my lord, the matter has been settled and the petitioner and the victim are residing as a husband and wife and they are blessed with a child. Lord, my lord. Item 62. Item 62. My lord says directed both the parties to remain present today because it was compromised. Because tomorrow is the Ugadi of Telugu people, my lord. They are unable to appear. May I pray on 15th? Oh, bless.
Item 48, my lord. On behalf of Mr. Das, my lord, kindly taken about 2 weeks after my personal difficulty. No,
After notice or fresh matter?
orders, yes, my lord.
Huh?
After notice, orders.
Fresh
Before
matter or
asking-
after notice matter?
Orders matter, my lord.
Orders. So we don't know who is just. Huh? Do you have any notice? 48.
My lord.
Interim order is there.
My lord.
Oh, wait.
Okay.
Yes. Yes.
My lord, on behalf of Mr. Das was not available.
All right, but when it gets called, you don't know.
Pardon?
Pardon, Lord, item 50. The lawsuit were directed for appearance of both the parties arising out of matrimonial dispute, my lord. So lawsuit may fix a time so that
2
item,
o'clock you let come.
my lord,
Bring them at 2 o'clock, we'll do it.
yes, 2 o'clock. My lord, actually problem is both are working outside. They have already made their return ticket yesterday.
What time he can come? Bring them.
To 12. Here,
12 o'clock you bring them.
my lord.
12 o'clock. When I'll raise and once again I'll sit and that time.
Item 84 minute. Item 84.
Yes.
After notice matter. 1 week after.
After notice, who is for the
Criminal revision. Criminal revision.
criminal revision?
Yes.
Wait, revisions I'll take.
Pardon to make a mention, my lord.
84.
Note it down. We'll see.
Pardon to make a mention.
Yes.
Page 7, item 72. I have already requested the other side. I am for the petitioner. May kindly taken up some other day. I have some personal difficulty today.
72.
Any other day convenient to your lords.
I beg your pardon, your lordships. I beg your pardon, your lordships. Item 12, fresh admission matter.
Wait, 12 till 12 you can wait. You are a young boy. Why should
Pardon
to-
Pardon to mention, my lords. Fresh admission. I filed CRLMC 708 of 24. Quashing of FIR matter. Kindly be taken up this week. But it is urgent in nature.
What? Watching a paper can't be because anticipatory bail is rejected. That's why I ended. He will see.
My lord mention for restoration.
Yes.
My lord mention for restoration.
Give the memo.
My lord mention for restoration.
Restoration.
Yes.
Item 70, your lordship. In that matter, your lordship directed to send it for a mediation center for a mediation. That 300, if I am correct, to replace your lordship number 307, which your lordship
Right.
found that no offense is made out, but let it be compromised between those who in-laws.
Litigation is still on.
In-laws. Say, say 10 तारीख को रही थी. Say that may be taken
72.
in some other day.
72. Item?
Item 70, 70.
Adjourn. Awaiting awaiting the mediation report. Adjourn.
Pardon to
Yes.
mention, my lord. Matter has been fixed to 27th of March 2024. May kindly be listed. CRLMC number.
Give.
I don't
All
know mention.
memo you give.
I don't know mention. Item 121, criminal revision matter, but no instruction is there, so permitted to withdraw.
One.
121.
Dismiss it. Withdraw. 120. Yes.
Obliged.
With the lordship's kind permission, may I-
Taken up next. Yes, my
Wait, 7 will come within 7 minutes. You Ma'am, know that may
I be permitted
to
make a mention, my lord?
You have a seat also, please take a seat. Yes. Yes,
May I
Mr.
be
Mishra?
My lord, item 106. This arises out of a conviction under 138 of the NI Act. I have talked to the client. He is positive for, because I am for the accused petitioner. He is positive about the settlement and he has already discussed partly with the opposite party. I am praying your lordship may only defer it for a period of 2 weeks so that I come back with a proposal for settlement because conviction itself will not inure to the benefit of either of the parties.
Right. Item
106 and otherwise also I am bereaved, so I am praying for a breather also.
Okay. 106, right now. Mr. Samir Kumar Mishra, Learned Senior Counsel submits that the present revision is arising out of a conviction under section 138 NI Act. The parties are willing to settle the dispute. Therefore, to explore the possibility of settlement, he seeks 2 weeks time. Accordingly, the matter is adjourned for 2 weeks.
2 weeks, lordship may defer. I will come back with a
Fix a date after 2 weeks. Okay.
obliged.
To phrase Belgium matter.
Belgium date.
Yes.
Belgium date. Yes. Let us start. Item 3.
Item C.
Yes. Yes, sir.
This is a matter where I have filed the case for quashing the PMLA proceeding. But in the meantime, I have filed an affidavit on 26/2/2024 indicating the subsequent developments. Because
On.
this matter relates to non-payment of the bank dues. Therefore, there was a simultaneous proceeding and matter went to Honorable Supreme Court. Honorable Supreme Court, that is in the matter of OTS and other things, because they have passed a judgment disposing of the matters by saying that all criminal proceedings in the matter shall be dropped. Besides, they have extended the time for payment of money and all those
Where
things.
is that order?
That order I have annexed it, my lord. Annexer,
My lord, I have not received a copy of
at
that.
page 8, annexer 1.
I'll just.
Yes. To my letter dated
Page 8.
yes,
Annexure 8.
annexer, annexer 1,
Annexure.
A by 1. To my affidavit dated 26/2/24.
Okay.
Copy the end.
To your affidavit. The affidavit is not there. Where is the affidavit? The affidavit hasn't come on record.
Oh.
Can it be
That's
tomorrow?
perhaps with the reason Mr. Agarwal has not received.
I have also not received.
I have got the receipt, but I will give you another copy.
That is not
I'll
from
keep
my
it next
office.
week, anytime. I'll keep it next week. Please give a copy to Mr. Agarwal.
Sure.
He'll verify and then we'll do.
One more extra copy I will give, no problem.
No, I have not received it. That receipt is not from my office. You
Doesn't
might have given to
let's
separate-
not enter into
Let it be
dialogue.
on 15th, sir. 15th or 16th?
15th, your lordship.
15th, okay. Please give a copy. to
I will
the-
have definitely.
Yes.
Obliged.
15th. Yes.
May I please, your lordship? Your lordship, the conducting counsel is not there. Your lordship, may kindly
Adjourn.
adjourn. Yes.
Adjourn.
Obliged.
But this is the time you should have prepared and come and argue.
Your lordship, my senior has prepared for this matter, so he wants
You
to.
can also prepare what is the cause. Anyway. adjourn.
Obliged.
Yes.
Taken out 2 weeks after, my lord. In similar issue, my lord, your lordship judgment reserved. Judgment has not,
Okay, after-
2 weeks.
Item 6, my lord, there is a compromise deed.
Judgment 6 is reserved, my lord. Coming under that, my lord. 376 is for auction.
POXO, okay, adjourn up to 2 weeks, 2 weeks. Yes. 7, where is that then? Yes. I'm so worried too. But what do you want?
I prefer adjournment.
Speak loudly.
I prefer short
What
adjournment.
is this matter?
Challenging the order of cognizance.
Cognizant. Why do you want an adjournment?
Mr. Pradhan is ill, so kindly take a moment.
Okay, adjourn.
May I please, your lords? My lord, last occasion, your lordships wanted to get the charge sheet, my lord.
Here in this case, my lord,
What do you want?
the petitioner is a advocate. Allegation is against her that is she's a lady. Allegation against her that
That's the only ground. That petitioner is advocate.
no, my lord. She was no, my lord. She was providing legal service. My lord, the
What are the offenses?
husband of the my lord 420-406. The husband of the petitioner was serving under the complainant.
Okay.
Allegation is that the husband of the petitioner provided a barcode printer by taking from one customer to another.
Okay.
The allegation is that the present petitioner picked up the phone and stated that the barcode printer has already been sent by my husband. This much of allegation. They stated that the in connivance with her husband, the present petitioner,
This lady is a lawyer.
my lord. And for that reason, the informant also has filed a suit, my lord, for recovery of his
Why
money.
don't you settle it?
Exactly, madam.
Settle it. You are a lawyer, you can pursue it.
Madam, also say they made the party, madam, at the in front of opposite party to.
Opposite party.
It can't be settled, madam.
You should notice to the opposite party. Number two, how many cases are there inter-se parties? Only one case.
My lord.
And a suit.
My lord. Suit against that the person who has bought that machine.
Anyway, but between these people, only one case. The only one case.
My lord, that suit has also already been dismissed, my lord.
That apart, I am talking about this suit is not related to you.
No, my lord.
If this criminal case is only one criminal case against you or some?
No.
It is only one. We will issue notice. Issue notice to the opposite party number 2, Mr. Ragada, accept notice for opposite party number 1. Opposite party number 1. Mr. Samad, response for the petitioner submits that there is the petitioner is a practicing lawyer, and there is no substantial allegation against her. However, the allegations are all allegations are against her husband. There is a possibility of a settlement outside out of court as well. Taking into consideration the aforementioned fact, issue notice to opposite party more state agency. In the meantime, the proceeding before which court? Investigation is on or cognizance taken? Cognizance, which court that is?
My lord, in the court of the law and JMFC 4
proceeding in GR case number 385 of 2017, arising out of Chawliaganj PS number 47 of 2017, pending before the court of JMFC 4, Roman 4. Cuttack is stayed till next date of it. But this stay is subject to condition that you will settle. I'll send it to mediation. Shall I send it to mediation right now?
After his appearance, my lord? After appearance of the
No,
affidavit to, my
thank you,
lord.
medicine.
Mediation jai karo.
Okay.
At this stage, Mr. Samal further submits that since there is a possibility, since the petitioner is a lawyer and there is a possibility of settlement, the matter may be referred to mediation. Accordingly, the matter is referred to the High Court, Orissa High Court mediation cell, and the coordinator of the mediation cell is directed to issue notice to the parties by fixing a date for exploring the possibility of a settlement, awaiting the mediation report. Leaves the matter on. Coordinator will issue notice.
My lord.
Then, if something happens, finish it up. Yes.
9, my lord, matter has already compromised, my lord. Matrimonial dispute. Some authorities of both are appearing.
When?
23rd, my lord.
23rd, okay. 23rd.
Oh, blessed.
Yes. 9:30. 10. Possible.
Item 11.
Item 11 may I plead your sir.
Yes.
When I'm challenging the order of cognizance,
Hmm.
I'm a witness to the agreement to sell. Present petitioner is a witness to the agreement to sell,
Hmm.
and the informant has not invoked the civil jurisdiction. Instead of that, they are filing the petition under section, filing the FIR under section 420.
Where is the charge sheet?
Charge sheet is under annexure 3, my lord, 16 to 22, page number 16.
What are the allegations? You are the witness to the sell deed.
Witness to the agreement to sell, my lord. The allegation is that the other accused has agreed to alienate the property through agreement to sell. Sell deed has been executed, and I am an witness to that agreement to sell, my lord.
Let us see, read it. During the course of investigation, previous to reach this point. You are Biswajit Sharma.
Biswajit Sharma, my lord. The FIR is under page number 10. If lords will allow me, I'll read the allegation against.
Yes, Mr. Ragada, let's see what are the allegations.
But both are.
There is an agreement to sell.
But both are two brothers, my lord.
Maybe, my lord.
My lord.
There is an agreement to sell. 17 lakhs was paid for selling of a property,
My lord.
a plot.
My lord.
The allegation is the property was not sold to him, it was sold to someone else.
My lord.
You can file a specific performance suit, you can file whatever recovery and what is the criminal case is about?
ସେ କହୁଛନ୍ତି ମାତ୍ର ସେ ଆମକୁ ଏଇ ଘର ବିକ୍ରି ନ କରି ମଧ୍ୟରେ ଏହାକୁ କୁମାର ବେଉରା ଦାସ ନାମକ ବ୍ୟକ୍ତିକୁ ବିକ୍ରି କରିଦେଇଛନ୍ତି। ସେ ଆମକୁ ଠକି 17 ଲକ୍ଷ ଟଙ୍କା ନେଇ ପଳେଇଛନ୍ତି। ସେ ଟଙ୍କା ଦେନ ନର୍ସ ତାଙ୍କ ସାନ ଭାଇ
Money is right, but you can where is the specific performance suit? Where is the see, section 20 will go in oblivion or what?
But 420 is clear. Liability cannot go, my lord.
You can't stress so much, you know. We are already burdened.
It can be settled.
We are already burdened.
My lord.
Ajab, since your brother has taken 17 lakhs, will you pay it? I will quash it.
Exactly. Exactly. That is
He is
Don't say no. You have taken the money, you have to pay it.
No, my lord, I have not taken. I am only.
Your brother has taken. Yeah,
Brother,
the moment I'll stay, your brother will also take benefit out.
No, my lord. He is another. As regards to my the present petitioner is concerned, the proceeding I have filed, my lord.
I am asking about one thing. Have you and your brother have taken the money or not?
My lord, another CRLMC I have also filed as regards to the brother. In that, I'll list the matter if lordship will direct to the mediation.
Give me the number of that CRL.
Right now,
Give that number.
I'm unable to.
Give that number.
My lord may take in another date. I'll.
No, you give that number to our court master. Both the petition will be listed on 22nd. List on 22nd. You give the number.
My lord.
Okay.
Deep.
And get ready with the money. Pay it, and I'll quash.
Then the civil suit will
everything will go. Don't worry.
They have not filed civil suit, my lord.
That's right, but see, I'll tell you. What was the date of agreement?
The agreement date is, my lord, agreement is 27/9/2014.
What is time bar? It is time bar.
It has already been time barred. It has already been time barred, and therefore
that is the reason they filed the criminal case.
that is what I want to submit, my lord.
So you can't take have the cake and eat it also. You have to pay it back.
No, but as regards to
you have used that 17 lakhs. You may not pay interest, but at least the principal amount you have to give it. Okay, anyway, we will take it up both the matter on 22nd. Give the number.
My lord, I'll.
1 minute. Shall I send this case along with the other matter to mediation?
Yes, my lord.
You pay? In the mediation you pay?
My lord. Matter may be go to mediation.
This is the case where mediation item gets
11, my lord.
Write down. At the instance of opposite party number 2, the opposite, you have not included. Opposite party number 3, the FIR numbers also came to the list. The allegation against the petitioner is, he is a witness to the agreement entered into between the opposite party number 3 and his brother. For the purpose of selling a plot, which plot number?
Plot number, my lord. Khata number 1330 by 6428.
Plot number 11066.
Plot number?
Page.
In order to sell the, there was an agreement to sell, entered into between the opposite party number 3 and the main accused, who is that, the brother of the petitioner, for selling the plot number
1106
by 9837.
by 9837.
plot number 1106/9837.
Unit 38.
Satya Vihar.
Unit 38.
Satya Vihar.
Pandra Mauja. Unit 38. Pandra Mauja, District Khorda.
38 Pandra Mauja. Even after entering into the agreement to sell, the main accused, the brother of the petitioner has sold the property to someone else. Therefore, the FIR was lost. It appears to be a don't give opinion. Issue notice to opposite party number 3. Since the matter pertains to a money transaction for the purpose of sale purchase of a particular sale purchase of a plot, there is a possibility of settlement out of court. Therefore, the parties may be relegated to the High Court mediation cell. High Court mediation cell. Accordingly, the matter is referred to mediation. The coordinator of the mediation center of the High Court is directed to issue notice to the opposite party number 3 and the petitioner, fixing a date, and thereafter explore the possibility of settlement, awaiting the mediation report, release the matter on 26th. On 26th.
My lord, may I pray for any other date than 26th? Any other date than 26th, my lord? 29th, may I pray for 29th, my lord?
Okay, 29. What else you need?
The matter is running, the trial is going on in the lower court, my lord.
Right, only cognizance is taken, what is not.
No, my lord, the notice has been, we have already filed the appearance plea, my lord.
The petitioner is permitted to move an application before the court below, informing regarding the matter being referred to mediation.
Yes.
See.
Your Lordships, on behalf of Learned Counsel, Mr. Biswajit Ranjan Tripathi, I seek for an adjournment, Your Lordships.
Adjourn.
Obliged, Lordships.
13.
Password.
Item 14. 14. 15.
May I please, Your Lordship? This is a matter for Your Lordship that for the questioning of the criminal proceedings. What has happened, Your FIR, there is no name of the petitioner. Then Your Lordship, in the preliminary charge sheet also, there is no petition name was not there. So therefore, the Lordship said that wait for the final charge sheet. In the final charge sheet, Your Lordship, petition name is there as an showing as an absconder. So, my lord,
Now you are charge sheeted accused.
yes, therefore, my lord, what I'm saying, a coordinate bench, this on similarly fitting has granted a protection that surrender and religion bail. I'm just passing up this.
Surrender who stops you?
My lord, this is that observation that is being spotted.
The prayer for adjournment rejected.
No, therefore, your lordship in the seat, therefore, in the 482 only itself only. He was in the.
Nobody.
No, that's why. So therefore, because this is the in the bench has passed this order. Similarly, footing this person.
Ideally speaking, I don't pass this kind of order, but
My lord, what happened? The petition name was not there up to preliminary charge sheet. Now it has been submitted absconded. No allegation in the affair.
Mr. Devji, then counsel for the petition submits that petitioner's name was not in the FIR or in the first in the preliminary charge sheet.
Yes.
However, the supplementary charge sheet has been filed on which date?
My lord, I have already
Filed on. Supplementary
filed
charge
on.
sheet is filed on.
That.
Date का 5/7/2023.
Yes, sir.
In said charge sheet petitioner is shown as a absconder. Absconder. Also, he is challenging the entire criminal prosecution initiated against the petitioner. However, he submits that at this stage he doesn't want to press this petition and seek liberty to appear before the court below and avail his remedy under law. Let the petition is disposed of with the liberty to the petitioner to appear before the court below on or before 30th of April.
Applies for bail and the parity
30th April and avail all legal remedy under law. If such application is if the petitioner surrenders and moves such application, the same shall be considered on its own merit on the same day.
Parity, my lord.
On the same day, parity will not evaporate. Parity is there. Either I say or you don't say.
If your lordship will say, then only then that it can be
If
available.
parity is there, it is parity.
My lord, parity because
He
there's
presses the application on all the grounds, including the parity.
my lord, deeply obliged here.
Parity is there, either I say or don't say. Yes.
Item 16.
I'm 16 also prefer one capital.
Yes, urgent.
17.
Okay.
May I please, the Lordship?
Yes.
The Lordship, in the present case, we filed the joint affidavit on the last occasion, Your Lordship.
Where are the
I am for the complainant.
The
where-
parties are present, Your Lordship.
parties? Bring. Mr. Maharaj, just verify.
Inspection officer.
498A.
Other condition.
Lingraj.
Code
also.
63.
Where is Lingraj?
Yeah, I believe 56.
Lingraj.
56.
Husband and madam is.
Daughter of late Ramanand.
What is the terms of the
Late Naman-
2 lakhs
Ramanand.
just taken. CS Ramanand.
and separately?
Separate.
The opposite party number 2 and the petitioners are present in the court. They are being represented by their respective counsel and identified by them. They filed self-attested copies of their Aadhaar card to establish their identity. Taken on record. Have you filed a joint affidavit? Or anything?
Yes, Your Lordship.
Yes, ma'am.
The parties have filed a joint affidavit dated it is 12/2/2024, Ventralia stating that they have decided to part away, and opposite party now petitioner has also paid permanent alimony to opposite party number 2 to her satisfaction. The opposite party number 2 who is present in the court is endorsing the fact that she has already received the permanent alimony, and she doesn't want to proceed against the petitioner in the present case. Mr. Rahul and Mr. Maharaja appear for the state, submits that since the parties have settled their dispute amicably and filed a joint affidavit, and since the dispute is arising out of a matrimonial discourse, there is no legal impediment in quashing the FIR, taking the consideration for subsequent proceeding and
Grateful, Your Lordship.
there is only one accused.
Yes.
One accused?
Yes,
How come?
I may be excused, my lord. I don't know about 13 and 14, your lordship. 13 and 14.
Fast over, sir.
But your lordship, Oklahoma,
Fast over, will come at 2 o'clock.
not here, on Monday.
And then what do you want, by the way? You want an adjournment? Then you do it. Then you, yes.
Item 18.
18 my lord, quashing of criminal proceeding on the ground of compromise. Your lordship may kindly see flag A. This is the affidavit filed by the informant. Here my lord, father and son. Petitioner is the son and informant is the father.
Where are they?
I am appealing for the.
But they have to be here.
Yes, my lord. Friday, your lordship.
My lord.
Yes.
Friday.
19.
May I please, your lordship? My lord, impugned order is at Annex 4, my lord. Is the second journey of the petitioner before this honorable court. Earlier, my lord, he has approached this honorable court, my lord, by filing another CRLMC, my lord. Wherein, my lord, the order under section 480-57 of the CRPC passed by the London SDGM was under challenge, my lord. This honorable court was pleased to, my lord, pass an order directing the petitioner to move the revisional forum. And accordingly, my lord, that CRLMC was disposed of with a liberty to the present petitioner to approach the revisional forum, my lord. So, my lord, revision was filed challenging the 457 petition, my lord, the prayer to defreeze the account, my lord, which was rejected, and again, my lord, against the revisional order, I have filed the present application.
What does it say?
My lord, Annex 1 is the FIR, my lord, against the present petitioner. Under section 420-336.
Come to the impugned order. What does it?
Impugned order, my lord, by the Annex 4. There's
Page.
Annex 4, my lord, at page 28. Relevant portion is, my lord, you lordship kindly see, my lord, page 32.
33-0, I'm reading that.
Yes.
Paragraph 5. Submit that to protect the purpose from gross irregularity. What is the reasoning?
The reasoning, my lord, they have given the reason, your lordship kindly see, my lord, 33 page 32, my lord, para 82.
32. Come.
They are saying that, my lord, they have not.
Which paragraph? The main contention of the petition is that
yes,
for such
deeply,
of the account,
they are not able to pay money to their creditors.
Our verification, the case record. What are the grounds?
Ground, my lord, they have stated this is the only ground that apart, my lord, the co-accused persons, the 8-3, my lord, another ground has been given, my lord. The co-accused persons, namely Ashok Kumar Mishra, Harish Kumar, belong to the state of Bihar. They have not been apprehended, my lord.
What are the allegations against you?
Allegation against me, my lord, I am an agency, my lord. I am the proprietor, my lord.
This petitioner is main.
I'm submitting. I'm
Who has been stocked and supplied the spurious medicine, my lord. On what ground the IO has been freezed the account? My lord, this is a factual aspect, my lord. So let's make and allow to me take the instruction from the concerned IO, my
lord. That apartment, another submission, my lord. 2 applications were filed, my lord. Many cases were filed, my lord, during that time, my lord, regarding the spurious drugs, my lord, Telma 40. So, my lord, in another case, my lord, I have also annexed Annexure 8, my lord. Similar cases, my lord. And for another proprietor, my lord, this honorable court has allowed for defreezing of the account, my lord. My learned friend maybe, my lord, take instruction in this regard.
That is one of the ground?
Yes, ma'am.
That's one of the.
And since because they are not, this is a loan account, my lord. And
then the light of Annexure 8, just seconds.
Yes,
sir. Okay. Issue notice. Yes.
May I submit a copy to my learned?
Yes, definitely. You have to give so that he will have to do it.
Item 20.
Yes, 20.
May it be, your lordship. My lord, the petitioners filed this application with a prayer to quash the further proceeding in city 1 of 2020, now pending before the OPID court cut off point. That the petitioners are of mother and elder brother of the main accused, who was the agent of Artho Tattva Group. It is alleged.
My lord, I may be pardoned, my lord. This matter belongs to the OPID matter, my lord. But the OPID advocates are not.
You are an accused in the Ortho.
No, my lord. It is alleged that I persuaded those persons to deposit in the Ortho group of institutions.
You are not accusing that.
No.
Let the OPID counsel come. Simply I issue notice.
My lord, my lord,
Simply issue notice.
my lord.
Simply issue notice. We'll see.
And the CD may be called. Obliged.
Yes, next.
21.
Yes, sir.
The annex 2, page 11. This is the notice on system CRPG issued to me, lords.
Against that you have come.
That is the type of.
160 notice only.
That is not permissible beyond the jurisdiction also. This case is now also West Bengal. And I am no way concerned so far the case is concerned. On the case, my son.
Which police station has given it?
This is the police station, lordship.
Tabis Pragana, my lord.
Huh?
No. The PS
Dum-Dum.
Dum police station.
Dum Police Station, my lord.
PKPC.
It is their jurisdiction, my lord.
Dum police station. And in the Dum police station, it is generally that the vehicle of my son was detained in.
Where is the FIR?
The FIR also have not been received. I only received the 160 notice also. So it is
How do I have the jurisdiction?
Mujla?
How do I have the jurisdiction?
LOC, yes, I am coming to the 160 also.
It is in regard to some FIR.
That is outside of the jurisdiction.
Registered in NDPS Act. There in Calcutta.
That is
And
against my son
notice
also,
is
not
issued to
against
you.
me. LOC, I glance the notice first of all, what the language they have been written also.
Ah.
You are the
Rajalakshmi Muni.
Yes, Milo.
So and so.
You are the relative, the owner of the
relative of
vehicle.
owner of the vehicle, so and so, namely, so and so. It is only for the purpose of investigation, some notice is issued.
Correct, Lord.
FIR
Yes,
is
Lord,
lodged in
glance.
the
No,
Calcutta.
it is no way permissible. It is no way permissible. 160 Lord, have glance.
Yes.
Yes.
But how can I see the FIR is in Calcutta?
She has to
What
move-
jurisdiction I have to go into all these things?
Because your lordship, the part of all the notice they have been issued to me, I am here, your lordship.
No.
Why should I go there? The 160 notice, lordship, a glance, lordship.
160.
160, the provision 160, lordship, a glance. Then I have also placed the some judgments. Police officer power to.
You tell me, how do I have the jurisdiction?
Then your lordship.
He has to go before the appropriate court, my lord. He has to go
Maybe
to
you
the
are
appropriate.
maybe 100% correct.
Yes, ma'am.
160 notice could not have been issued. Then the Calcutta High Court has to go into all
Own
these things.
jurisdiction.
How can I go into all these things?
Lordship, glance, in the mail of the latest development is that, your lordship. In consonance of
Even
such
in
notice.
the case of anticipatory bail, the courts have said that if you are staying here, I can't
Then
entertain
your
anticipatory bail.
your lordship can issue a transit bail, your lordship.
160 notice
Issue a
is right.
transit bail. You
Not
issue
how-
notice, I am no objection.
No,
Issue
please,
notice, your lordship.
please, you have to go there only.
No, your lordship, I have to satisfy so far the jurisdiction part is concerned. The 160 notice, your lordship, clearly stated that the language is like this, your lordship. Any police officer making an investigation under the chapter may, by order in the writing, required to attendance before himself of any persons being within the limits of his own or any adjoining station who, from the information given otherwise, appears to be acquainted with the fact and circumstances of the case, and such person shall attend so as required.
You are in adjourning.
No,
any adjourning.
no, I am not adjourning. It has been clear in the judgment, your lordship. Adjourning jurisdiction means it is within their limitation of the state, your lordship, not
I am
beyond the
asking
state.
something else, sir.
It is not beyond the state. your
Because this is a matter arising out of an FIR registered in West Bengal. 160 notice is issued to you for the purpose of investigation. How do I have the jurisdiction?
This is,
Sitting in the
I am satisfied. So
Orissa
far,
High Court
jurisdiction
to
part,
entertain your petition.
Lord Sabha, jurisdiction part, I am
An
satisfied.
example for that,
And then second aspect, your lordship, in pursuance to the such notice, your lordship, my son appeared before this court, filed an application for bail, and transit bail was allowed. By virtue of that transit bail, that has been
bail is
regularized, your
there.
lordship. That has been regularized. And I am no way concerned so far the case is concerned.
regarding investigation, they only asked me to provide the detailed information about my son regarding the present address, your lordship. So my respectful submission is that, your lordship, if I am no way concerned so far the case is concerned, and my son was not with me, and my son already appeared before the court below, given his address.
I will record your statement that you go and appear before us.
I'll satisfy, lordship. I'll satisfy so far the jurisdiction part is concerned, some other day may can. Some other day. I
How
have
will you
some
satisfy?
judgment.
These are the facts, what?
No, I have some judgment. I have some judgment, your
Show
lordship.
me the judgment right
Yes,
now.
my lord.
This is not a constitutional issue where I should adjourn it. This is small
This
issue.
is only a glance. This is Jamshed Ali Khan and other versus Union Territory of Jammu and Kashmir and others.
What does it say? Irrespective of the fact that FIR
The
is written
jurisdiction
somewhere,
part has not been
notice is
discussed with, but
issued
that
to you appear
just like
in
on
the,
the relevant paragraph, let's see,
which paragraph?
27.
27. Okay.
By mere reading of the said provision, it becomes apparent that the power of the police.
27. Jamshed Adil.
Jamshed Ali Khan and other versus Union Territory of Jammu and Kashmir.
There is only 8 paragraphs in the entire judgment.
No, 3 or 4. Okay, here also a glance. This is also 40. 5.1 sub 27.
5.1.
5.1 27.
Okay. 5 point. Okay. Right on. In the above view recreated this also by a mere reading of the provision. Mere reading of receipt provision. What it doesn't say anything.
So, but jurisdiction part has not been stated.
So that's what you are missing the point. Whether the police had the power to issue notice to you or not, that could only be gone into by the competent court having the
That's
jurisdiction.
correct. So far jurisdiction part, so far jurisdiction part, I bring some judgment, keep it to tomorrow, day after tomorrow, I will satisfy.
Tomorrow.
Yes, ma'am.
Tomorrow. The best course is I will record your statement, and that is the best course. Don't waste your time. I'll record a statement that you will go and appear with the
verification so far jurisdiction.
and that would be it's kind of a transit bail to you. Go and appear.
Bail is not required to me because I am not the accused in the case in concern. It is only notice to my son to provide. And my son in the union has already been entered appearance.
Simple matter, safe accusation mobile number address.
Because why should I go there and why should I appear before your lordship? I am satisfied the judicial part tomorrow, lordship. Keep it tomorrow.
Come tomorrow. Yes.
22.
22 also I can take them along with 32 years. When 32 will come there, the compromise matter.
Yes.
32 so that party is true.
Party is
The affidavit of Korea.
32 no, 32 no. Upon also 32 times. Okay.
23.
Please, my lord, appear for the petition in this matter.
23.
Petitioner, my lordship, I am audible?
Yes.
Yeah, I am for the petitioner in this matter. Petitioner is a practicing lawyer actually in Bombay. It is arising out of a matrimonial dispute. An FIR came to be filed against her. And before that, actually, there were other criminal complaints lodged by the petitioner in Bombay and Noida, etc.
Matrimonial dispute 323, 508, 341, 294. And all.
Yes. And the
What is matrimonial about it?
My lordship may see the allegation. This is filed by the father of the husband. father of the husband against the daughter-in-law. And the
opposite party, number 2 is the father-in-law of
Father-in-law.
petitioner.
Yes. And the subject matter of the allegation appears, allegedly happened in Noida, not in Cuttack, because I never traveled to Cuttack. So all the allegations happened to be, happened somewhere in Noida, and the FIR came to be lodged after 6 months of the commission of the alleged offense.
Where you have beaten your father-in-law?
We have never been
Noida or Cuttack?
Noida. I never been in Cuttack. That is the another issue. I never been Cuttack, and this is actually filed as a counterblast because I filed two.
Let us see the FIR. Let us see the FIR.
It is a matter of my lord, 3/0/2022, my lord. Then now, what is the present status of this case?
Investigation is still on.
Yes.
Investigation is still on. They are trying to verify whether you have beaten your father-in-law there in Noida or Cuttack.
My lordship may turn to page number 4 just for a moment of my petition.
4 of what?
Petition.
Your, petition. Okay.
Yes.
Yes.
There is history of litigation and complaints between the parties.
Okay.
The first 2 petitions came to be filed by the petitioner.
Still you are married? Still you are married or separated?
No, I am actually in Bombay, and he's there, and the divorce petitions are going on. That is not been finalized yet.
10 cases.
And this second petition, there is a compromise affidavit also filed by this very complainant, saying that like, I will not trouble you, etc. That affidavit also is part of my petition.
Okay, let us see. We will issue notice because they appear to be family dispute and all.
Yes.
Issue notice to open. Written with 2 weeks. Yes, next. 24.
24.
Please, your lordship.
Your lordship remembers I made a mention of this matter, which my lord had posted to the 10th. On the day I made a mention before your lordship, the 3rd additional sessions judge has granted interim bail for 3 months.
You should be happy then.
No, I am not.
Simply I'll adjourn it. Simply adjourn.
But what I pray is let it be disposed of within that period. Your lordship may fix a date. So
Yes, before 3 months. First week of May first week of First week. Yes.
25.
25 is a compromising matter kindly taken over at 2 p.m.
Yes.
26.
26, your lordship, senior advocate R.P. Kaur is appearing in this case. He, due to some emergency, is not available today, your lordship. Lordship.
27.
May I please, my lord? My lord, this is a case of bail jump, my lord. The petitioner has been implicated under section 341, 294, 323, 325.
You were on bail.
My lord. I was in bail since 16th March 2022, my lord.
16th March
2022.
22. 22. NBW put on 14/9/22.
My lord, item number 27.
Yes.
27, my lord, copy not served.
How much you will pay?
Daily labor, my lord. He's a daily labor, my lord. The petitioner is a daily labor. He has gone to another state for the other.
Okay. You give 500. Okay. 500. You have to appear on or before 5th of May. Before court and seek remedy. Okay. 5th May. So 5th May. Okay. Yes.
28.
May I please, your lordship? My lord, the allegation is that a property has been sold by the undersigned, my lord, the petitioner, in favor of the informant. The sale deed is there. That it is 19. In fact, the sale deed has been executed, my lord,
by one Chittaranjan Mahanti in favor of Madhusmita Maji.
You are Neelam Kumar.
I am Neelam Kumar Swami.
Sai Darbar.
He alleges that through my company transaction took place. And on the allegation that in order to secure this amount, because he faced difficulties in recording the property in his name, in her name rather, my lord, she files an FIR before the court that I have cheated him. But a civil nature case, police although accepted it.
No, sale deed is already executed.
Sale deed executed.
What is cheated then?
Hello?
How have you cheated? He has paid the money, sale deed has been executed.
Executed by somebody else again. Chittaranjan Maji, who is the owner of the property. I am the mediator, he says. And by my lord pressurizing me, he has also received 6-7 lakhs from me. Statement of account is there. I am not.
What is the sale consideration?
5 lakhs 29. I showed it to you.
But what is the allegation? How much you have taken?
Allegation is that her husband had paid me some amount. She had paid me certain amount, and that check for 17 lakhs got dishonored.
So many things is there.
She is alleging that all are this. My primary is I will prove that it is a fabricated check. Whatever it is, that is something I can't say now. And now that being so, no cause of action survives.
What is the stage of investigation?
Investigation, sir.
Yes, Mr. Rao.
My lord, actually your lordship may kindly have a glance running page 10, para C, my lord. Para C and E is complete fact, my lord. My lord, that the PT complainant has given in different way 21,82,000 rupees, my lord. And promised to give a land. But that land has been registered to someone other. And by this process, he committed to return the money. And 3 lakh, my lord, running page 11, my lord, third para. 3 lakh are only he has returned, and the rest of 17 lakh.
Serious, need to investigate.
17 lakh 27,000.
So I need to go into all this thing at the investigation.
I am satisfied, your lordship. Page 10, your lordship looks at the paragraph 18. Paragraph C below, that as per proposal of the accused and of the active participant connivance of the complainant, finalized the deal purchase of the land Etiki, area of Etiki, 2000 square feet, MS Khata number 801/724 in Daruthenga, such and
That
such.
need to be investigated.
My lord, that is there in the sale deed. I don't say it should not be investigated. I never said
what
that.
I'm saying is, see, 21,82,000 rupees was dealing. 5 lakh sale deed is registered on the 5 lakh. What happened to the remaining amount? In what way you have taken the money? What promise you have made? I don't know at this stage. Investigation has to go on. Wait till investigation is complete.
My lord, there the 1CC case is continuing. There I am in bail. But then let that be stayed for the time being. Let him come back with the instruction, my lord.
See, it is investigation stage. How can I? Have you applied for an anticipatory bail?
No, I am there in bail.
Then what?
There is that's further proceeding in this criminal case, that 1CC complaint case, 138 and Act, that may be stayed.
See, I don't know what has transpired. How do I know?
Why I am submitting, my lord? I showed your lordship what she says.
I'll simply adjourn it, awaiting the charge. Otherwise, I should have
some indulgence 29th or 28th. Before that, your lordship may call it. Lower court is fixed to 29th.
29th, before 29th. Hey, Mr. Rahul, just check it up. What is the stage of investigation and tell you.
Yes.
Let it be on 26th. Let it be on 26th. 29th, that date is there. No?
Yeah.
26th, you tell me so that we'll see by that time.
Good enough, your lordship.
26th. 29th, see 138 matter. He wants to stay of that. So therefore, you please seek instruction what exactly has happened. We'll see on that. Okay.
In the meantime, I got a submission, my lord. There is bereavement in the family, so I may not be available for next 10 days or so.
The junior is very competent.
He is there, but I don't know.
No,
And this afternoon I am leaving. There is a matter after lunch. He will stay is there, so that is something. It's not. No.
29.
May I please your lordship? The present petitioner is challenging the cognizance and the criminal proceeding under Annexure 4, your lordship. The case is relating to Immoral Traffic Act. What happened, the sub-inspector of Chandrasekharpur lodged an FIR after getting reliable information for the raid on the Sonali guest house situated at Chandrasekharpur. And the FIR, two accused persons are there, who is Arjun Sahu, the another accused person who raid caught-handed in the room B4, from room number B4, and the manager of the guest house. And I am not the FIR named accused person. Subsequently, my name has been added, basing upon the hearsay witnesses, that the two major girl, that is Sonali Mahapatra and Pooja Sahu, named my name, that they have procured me to that guest house. CCTV camera footage is seized, and the mobile phone of the guest house manager as well as the Arjun Sahu, another accused person.
You are the pimp.
No evidence at all, except the statement. Unless the statement is Sonali Mahapatra and Pooja Sahu is verified, then I have no case. And that statement is there is no name in my name, then I have a good case. Because
show me the statement of both the girls.
that
Those who have
statement is
taken
not
your
with
name.
me. That statement is not with me. So that this case is based on this statement of Sonali Mahapatra and Pooja Sahu.
Because they are the victims.
No, they are the
They are
witnesses.
also the witnesses.
Witness
My lord, it's a matter of 2016, my lord. So perhaps the charge sheet will be.
No, charge sheet submitted, cognizance
Submitted.
taken. We are on bail.
Where are the charge sheet?
Charge sheet annexure 2. Annexure 2. Cognizance annexure 4.
Where are the statement then? Show me statement, charge sheet is filed.
The Sonali statement of.
I don't have that statement.
Yes, ma'am.
Otherwise, see, if only the Sonali and that girl, both of them are saying that he is a pimp, what are the other materials to connect him?
Yes.
That has to be seen. If that
Other material that is absent. Jadi Sonali कहते maximum 5 of immoral traffic, I may be attracted, none else.
Now, what are the offenses here?
Offenses is 378
capital A.
378 2 सेटा मो नार होनी 3457 only 5 maximum जदी आसीबो जद न आसीबो तो
70 capital A 2.
हां यस
10 years.
कि मो नार किछि नै तांकर रजिस्टर सी जेछि उभयंकर समस्तंकर मोबाइल सी जेछि मोबाइल सीडीआर यस सीडीआर कॉल डिटेल्स रिपोर्ट आसीबा दरकार मोर कोन कनेक्शन छि तांग संगे खाली हियर से विटनेस कहि देले हबन
देखो सर नोटिस सीडी this notice CD. Yes.
IA is there.
IA
First step.
issue notice on state here. Yes.
Item 30.
So, quashing on the basis of compromise.
Where the
Offense, my lord,
what
offenses are 420, 419, my lord. 31,800 rupees. 31,800.
My lord, actually there is a problem. There is the petitioner directed to surrender before the appropriate court in first hour, and if rejected, then second hour. And but the petitioner did not surrender, and again appear before this honorable court for ABLPL. And again, the honorable court has pleased to direct to him, go and surrender within some stipulated period. And after that, this CRLMC has been filed.
No, my lord. So, there are two petitioners.
What are the allegations against you?
Allegations, my lord. Petitioner number 1, my lord.
Cyber crime.
My lord, so petitioner number 1 runs a kiosk banking, that mobile banking, traveling in the rural areas. And
What
my
is
lord,
the stage of investigation?
my lord, stage is petitioner number 1 was arrested, released on bail. Everything has been seized from the petitioner number 1 and released also in favor of him. My lord, sir, thereafter, in the meantime, petitioner number 2 applied for anticipatory bail. In that bail application, petitioner number 2 was directed to appear first up and second up. My lords, in the meantime, my lords, there was a compromise and settlement. Before the trial court, my lords, informant gave an affidavit, submitted an affidavit. The certified copy of that, annexure 3.
Yes, my lord.
Page 19 to 20.
For how many people you have cheated? That's the question. not the only one. Because you have created some sort of bank and started cheating people.
No, my
The
lords,
one informant has given the FIR.
my lords.
Investigation has to
Yeah,
unearth how many people you have cheated. That's the difficulty.
No, my lords, only that involvement in the affair is 10 to 11 persons.
What are they?
31,800 rupees.
See, the manner in which you have
And
conducted the crime, amount is not important. You have one informant, see, there are 11 people.
na se neiki samastonko bhitere and in presence of the previous and present sarpanch there was a compromise and matter has been settled. Even if police,
if the sarpanch start exercising jurisdiction.
no, my lords, even if my lords, before the police has also recovered the 31,800 rupees from
What
the.
is Mr. Rahul, what is the stage of investigation? Because the allegations are a bit serious.
Yes,
My
my
lord.
lord, I have to take the instruction, my lord.
Let him seek answer.
No.
It's not so simple.
No, my lords, that certified copy of the
I know you have settled, with the informant, there is no doubt about it.
my lords.
Had it been an isolated case, quashing is no problem.
No.
But you have, they have to yet unearth how many people you have cheated.
No, FIR ରେ ଦେଇଛନ୍ତି ପରା 10-11 ଜଣଙ୍କ ପାଖରୁ
ତାପରେ ଇନଭେଷ୍ଟିଗେସନ କରା ପତା ଚାଲିଲା 200 ଜଣ କରୁଛନ୍ତି।
ନା
Investigation
ଇନଭେଷ୍ଟିଗେସନ ରେ ସେଟଲମେଣ୍ଟ ଅର୍ଡର ଟା ଏବଂ ଏଫିଡେଭିଟ ଟା ଆଇଓ କୁ ପଠା ଯାଇଥିଲା।
Please wait till
ଆସୁ, ପଳେଇ ଆସୁ, ଆଉ
Please
ଥରେ ହେଇଯିବ।
wait till next week. Let him get the instruction.
My-
I'll quote it.
My-
Nothing comes out, I'll quote it. What is
My-
No problem. I'll
My-
quote it. But let him get that.
My lord.
Mr. Rahul, please
Urgently,
get,
I'll call.
urgently see that get the instruction. What are the involvement? What are how many people he had cheated? Whatever, huh?
My lord.
And get the information by next date on 29.
My lord, sir, I pray further proceeding may be stayed.
Investigation, how can I stay, sir?
Further
How can I stay?
ନା ଟ୍ରାଏଲ କୋର୍ଟରେ ଦେଇଛନ୍ତି ଏଫିଡେଭିଟ ଦେଇଛନ୍ତି that was communicated to the investigating
now
officer.
Investigation is going on. You are on bail. What interim order? No, there is nothing. No threat to you. What threat you have? Tell me.
ନା ସେ proceeding ଟା
Co-proceeding.
ସେ ଯୋଉ ଜିଆର ପ୍ରୋସିଡିଂ ରେ ଏଫିଡେଭିଟ ଟାକୁ ଏଫିଡେଭିଟ was kept on record.
Still investigation is on.
My lord.
I
ସେ
keep it.
କରୁନାହାନ୍ତି ସବମିଟ କରୁନାହାନ୍ତି
No,
ରିପୋର୍ଟ
I am saying you have.
my lord.
Mr. Rahul, the counsel the state submits that he would seek instruction regarding the stage of the investigation in the present case. The counsel for the petitioner submits that the parties, the petitioners have settled the dispute with the informant and
Other victims also.
Other 10 alleged victim persons.
My
Victim persons. On that ground, he seeks indulgence of this court for quashing up the entire proceedings. He leaves the matter on 29th. In the meantime, Mr. Rahul, the state should seek instruction positively regarding the stage of investigation.
Investigation.
Positively, I have written.
My lord.
Yes.
31.
Yes.
Made page around. In the case, the petitioner is challenging the order of cognizance. That is page 68 onwards.
Yeah,
This relevant page is page 72.
You are so conveniently changing sides.
My lord, it is compulsion for me to come because the student is belong to is a ABP student and the question paper is disclosed by the board. The ABP students are agitating the same before the board, secondary board of secondary education. There is a might have some class tussle or anything. They want to enter whatever allegation with the president has given affair. Neither I was present nor I was participating in this. In the time of filing the charge sheet, let's see page 55, 19, they include my name because I am activist of the ABVP.
and they're given this address that Gopala Katak. I am not belong to Katak. We are the from native of Rajnagar, and we are staying in Revansa hostel. What happened now? In the meantime, I got the government job.
What are the allegations?
Allegation according to FIR that this question paper are disclosed. That's why the AVP group of AVP people sir came and agitated before the Board of Secondary Education Office. They try to assert this
Is the student movement?
student movement. Mass of students are there, public is there, but by,
What are the
That is the but all ABPP members, including the student members, they have all assaulted the.
This happens in the student time. So many things happen.
he got the government job. This is not the SU. Because of this case, he is hurting.
What is this? What are you asking by the way?
Well, this stay of this convenience order.
Issue notice to the name, Mr. Issue notice. First, Mr. Party, then counsel for the petitioner submits that the allegation against the petitioner is that. What are the allegations? Let us see. You are not named in the FIR.
I am not in the FIR.
Submit that the petitioner was not named in the FIR. However, after investigation, the charge sheet was filed on.
Charge was filed on 19.
You have 307 also. You have written people.
Yeah, 307.
Charge sheet was filed on 21/8/2018.
21/6, huh?
21/8.
21/8/2018.
Let's say that can be
2000
list of lectures events.
2018 under section so and so. It is alleged against the petitioner that when the question paper was leaked, the petitioner along with the other member of
ABVP, yes.
ABVP agitated before the
board.
Before the CBSE
Board of Secondary Education.
Board
Cuttack.
of Secondary Education.
Cuttack, Odisha.
And attacked the authorities. Attacked the authorities physically, which led to the registration of the FIR. The Mr. Party further submits that the petitioner belongs to Rajnagar.
Rajnagar, yes.
Petitioner belongs to Rajnagar, whereas in the charge sheet his name is his address is shown to be at Cuttack. Huh?
Yes. Gopal Sahi, Mangalabag, PD Cuttack.
Gopal Sahi, Mangalabag, Cuttack.
Apparently wrong.
He submits that his presence in the spot is also doubtful. Is that doubtful? Issue notice to the state, Mr. Maharaja accept notice, so and so. And in the meantime, the proceeding before so and so.
Yeah, Annexure 3. Yes.
Why don't you tender apology to the CBSE board and ask and we'll pass it? One tender apology, you all.
Yeah, future be saved.
Future will be saved unnecessary.
But
We explore that possibility.
but CBS authority has not given.
Who is the informant? Who is the informant?
Informant is the president
President
of the Board of Secondary Education.
Go and tell him.
But he has not given my name in the affair.
But all the other accused must be ABBP members only.
I'll suggest that. Then.
I suggest them go and tender apology. I'll come here and quash it. Finish.
Yes. Then it's better. It is better.
Proceeding, further proceeding in respect to this petition to be stayed.
Further proceeding for the petitioner is stayed.
Yes.
Because all are young students.
Yes.
They're,
No, so only this person I find, this person is a young student and he has already got the job. That paper
he has got the job in the secretariat as ASO.
ASO.
Larsimesi pays 73.
Assistant section officer.
So anyway,
So only Larsimesi observed that in respect to Annexure 4, no cohesive action shall be taken by the government.
Yes.
I'm staying the entire proceeding.
So only one sentence will survive his service because then.
If I stay the proceeding, everything goes. Where is the question of
Oblige.
it's beyond no course.
Yes.
And he has already joined the
Yes.
service.
He joined, but because of the criminal case, they are kicking out also. Oblige.
Give it.
Long date. Long date.
Long date. Meanwhile, if you can pursue.
I'll pursue this bias. Yes. I don't know all this, but I ask already and I tell that you give an oblige.
Put an end to it.
Just a content.
Yes.
I'm just
Mobilization.
There is a passing somebody.
Yes.
1232.
Medicine.
Both are able to arise to 1 year. In the binary case,
Same FIR.
Same FIR.
Yes.
Same FIR, 180 lordship. And I have been supplied the affidavit so far the 2 is
Yes.
also. It's fine. And so far 32 is fine.
358 ଗୋଟେ ଆସିଛି CRLMC ଲସି ମେକାନିକାଲ ସି 358
350.
ସେଟା କଣ ମୁଁ ଜାଣିନି କାରଣ ସେଟା ପେଣ୍ଡିଂ ଅଛି ବୋଲି ସେଟା ଗୋଟେ ଲେଖା ଆସିଛି ସେଟା ଆସିଛି ତା ସାଙ୍ଗରେ 358 CRLMC ନା ସେଟା କଣ ଅଛି ବା ଲିଷ୍ଟ ଇଟ୍ ଅନ୍ 4/4/2024
କଣ what is that?
CRLMC 358 of 2014
Just tell me what is that?
ସେଇଟା କଣ ମୁଁ ଜାଣିନି ସେଟା ସେଟା ଦେଖଉନି କିଛି ନେଟ ରେ କିଛି ଦେଖଉନି but that has come
No, item 22. That is item.
That is item 22. That is filed on behalf of one person.
22 is
358 of 20.
CRLMC 358 by
Same FIR.
24.
Same FIR. One accused has filed item 22 and
yes.
the other remaining accused filed 32.
32.
That's what you are saying. Okay. FIR is same.
ଠିକ ଆଉ ଗୋଟେ ABLPL ସେଟା ରେଫରେନ୍ସ ଦିଆ ହେଇନି ରେଫରେନ୍ସ ଦିଆ ହେଇନି କିନ୍ତୁ ସେଟା ଫାର୍ଷ୍ଟ ଅର୍ ସେକେଣ୍ଡ ଅର୍ଡର ଦିଆ ହେଇଥିଲା ସେମାନେ ସରେଣ୍ଡର କରିନାହାନ୍ତି
ନ କରି ତ ସେଟ୍ କରତେ
କରିଦେଇଛନ୍ତି ଆଉ
what are the allegations?
ଖାଲି ପୁଅ ଝିଅଙ୍କ କଥାକୁ ନେଇକି ବିଚାର କରିବା ଦରକାର ତାଙ୍କ ଛୁଆଟା ହେଇ
Executive petitioner Gulu and Siddhartha Kumble. Annexure 1
And you are,
page.
okay,
Hello?
you are on bail. Bail. When you got
Yes.
the bail?
Yes, my lord.
Tell me the date.
My lord,
Have the date.
my lord, order number 6787 Annexure 3 page 15.
28/7/2017 bail. ठीक है जी तापर NBW issued on
13/3/2023.
Okay, 500.
Yes, my lord.
Okay.
34.
34.
On
On behalf of Mr. Manti, Your Lordship, Belgium matter. Petitioner was on bail 22/6/2017 and NBW was issued against him 3/11/2022.
500. Yes.
35.
35.
35 also same, Your Lordship.
Same.
Belgium matter.
Date?
Bail, he was on bail 29/2021 and NBW issued 8/2023.
ठीक है जी 500. Yes.
36.
36 on behalf of Mr. SS Rai. And
NBW 2120 1000.
7 accused
7 accused, my lord.
7 accused
My lord.
तो 500
each 500
500 each. ठीक है. It should be 1000 each because you appeared. Yes.
37.
My lord, it's a Belgium matters.
Yes.
So in NBW issued on dated 24. Aye.
ठीक है. Bail
Bail rescission petition 14/11/2003.
14/11/2003.
Right.
ठीक है जी 500. Yes.
38.
item 38 lordship matter relating to Belgium NBW has been issued on 28/10/2019 lordship
2010-2019 bail.
bail is when he was on bail but the exact date has not been
He was on
mentioned
bail. और 28/10/19 କେତେ ଜଣ ଅଛନ୍ତି?
ଜଣେ
1000.
lordship
1000. Yes.
39.
Warrant issue 21/6/23.
NBW on
21/6/2023.
bail
3/6/2019.
3/6/2019. ठीक है 500. Yes.
40.
May I please, your lordship. Belgium matter, my lord, petition released on bail on 29/11/2023 and NBW issued on 5/1/2023 annexed of 2 series. 24
5/1/2024
my lord.
And bail to the 500.
Public.
Yes.
41,
My lord, NBW issued on 18/5/2023, my lord.
Hmm.
Then granted bail on 24/3/2023, my lord.
24/3/2023 bail. NBW 18/5/2020.
Same order be passed in CRLMC number 378.
500.
378 your lordship. Same order.
Which one?
378. Seithre annex rahichi. CRLMC 378 of 2024.
That's a separate one.
In respect of a co-accused. Same Belgium. Same Belgium.
In respect of out separate kar do. CRLMC number 3.
No, my lord, say that is a disposal of case, my lord.
Dispose mane
Say case re
yeah, out accused.
500.
My lord.
42,
My lord, the petitioners were on bail. NBW was issued on 9/11/2021.
Bail ke bhi
Bail, so far as the petitioner number 3 is concerned, he was released on bail on 26/7/2013.
26/7/2013.
13 and petitioner number 1 to 2, 16/7/2013.
1 to 2, 16/7/2013.
13.
And
my lord,
3
in this case, I am absolutely informant.
42 run ahead of 40.
42. To Belgium matter, my lord. Belgium.
Are you opposing?
I am informant, my lord. Oppose the.
Not
medical, my lord. My lord, can you see?
He will appear and seek remedy, whatever remedy. There you oppose. Why? I will enter your appearance. So appears for informant.
My resolution submission, my lord. My lord, kindly see order dated 13/3/2024 passed by the Litigation Cutter Sadar. 13/3/2024.
भूल एप्लिकेशन आपण अपीयर करछन्ती ए नुह आज्ञा आपण एथरे अपीयर कथा 43 रे आपण अपीयर कथा एटा मु जानछि एटा इलीगल 43 जोटा अरुणा कुमार सेठी तो
आई एम एप्लीइंग त्रिपाठी राइट त्रिपाठी हां अच्छा कौन
हां कहले
कौन व्हाट डू यू वांट
But what my lord, in this case, already my lord, when you see the order dated, that is a
tell me what you want.
9/11/2021 to their Jones.
That's right.
Therefore, 4 witnesses are already examined.
That's right. Do you want that they should be permanently?
No, my responsibility is not grant bail. She has given to custody because my lord, the order sheet.
Can I pass an order for taking them to custody?
My lord, 13/2024.
Sir, I am only giving them. They will go and appear and move appropriate application. If they are entitled to bail, they'll get bail. If they are not entitled, it will be rejected. Oppose there.
Yes, my lord.
What am I? I am not doing anything.
Sir, my presence may be recorded.
Yeah, I will present and record. Present and record. NBW issued on no 11/2021. And he will appear before the court on or before 5th of May and move appropriate application in accordance with law.
आपण बेल लेथिले तो
No, bail re mutile. I was
on bail.
I was on bail. We are on bail, man.
I am not saying anything. I am not saying anything. You go and tell that. On merit, it will be decided. 500. How many of you are there? 500 each. 3 jana. 43. And so appears for the opposite informant and vehemently opposed. And finally written objection.
Adi first time tells
He has to justify his presence also. 43. Yes.
Lordship, the NBW has been issued on dated 5/2/2024, your lordship.
5/2/24.
एने टंका देबे एथरे हबनी yes 1,20,000 error maintenance pending, that is why warrant has been issued.
Go and pay.
तो पेमेंट करिवे तल जानदो
I'll keep it in advance. You go and do it. I'll advance for the one.
Yes.
at events till 5th and appear there and satisfy. Otherwise, again, it will be revived. I am only keeping it in events.
Yes.
I'm not setting aside.
Till 5th. Yes.
Till 5th, I am keeping it in events. I events for that.
Yes.
You go and appear and pay. Otherwise, it will revive.
Yes.
Okay.
Develop like.
44.
May I please your lordship? The petitioners was on bail 18/9/2017. NBW issued 4/3/2024.
Okay.
3 accused.
500 each.
45.
May I please, sir, Belgium matter, your lordship, and it was in bail on 9th January 2018. NBW issued on 20th April 2023.
23.
Yes.
500.
Yes, sure.
How many of you are there?
One.
500. Okay.
Obliged.
46.
Bail on 6/4/2011 and NBW was issued 10/11/2024.
20? 23. 500. Is taking note it down? Yes.
47.
No, 47.
May I please, your lordship?
Yes.
Lordship, I am in jail custody since 23/12/2023.
Only pray, my lord. President not there, my lord.
Only pray the another matter BL appeal number 241724 adjourned to 10th, my lord.
10. Let it go.
No, one of the co-accused has already been released.
10. 10.
My lord.
Okay.
2417.
241724.
10. Okay.
Obliged.
Next.
48.
48 it's a writ petition. I have entered my appearance for intervener petitioner
Why this petition is there?
because it was placed before Honorable Justice BP Satrapati as he was concerned. For that reason, it was assigned to this honorable bench.
Last time nobody appeared.
Last time appeared, the petitioner counsel appeared and prayed for to file objection to the intervention application, my lord. They have, even though they have filed an objection, but the copy has not been served on me. The objection is at play.
Non-appeal for the petitioner in the interest of justice, adjourned to.
Well, there is an int.
To continue till next date of hearing.
I only pray that a short date may kindly be.
Short date go. Next time, if nobody comes, dismiss the matter.
And the direction to serve the copy of the objection to
Do
the.
whatever you.
No, I am for the internal petition. The petition.
Who stopped you? Do it. In any case, you have to give.
Obligation.
49.
Immediate vigilance. Here, my lord, the connecting file is before my lord. That is CRLMC 3120 of 2023. Where, my lord, both the cases, the present case as well as that 3120 of 2002 was heard by my lordship. And may kindly have a glance over the order passed on 22nd February 2024 in CRLMC 3120. My lordship has observed that my learned friend Ragod was there and he considered that paragraph 4, my lord.
Para 4.
Para 4. So my lordship was
Mr. Raghunath,
please
to submit that since the dispute is essentially arising out of a matrimonial dispute and the parties have now settled the dispute, yes.
But my lordship could not pass any order because it was not assigned at that time. That is the only hindrance for which I cannot able to get the relief. And it was placed before my lord Chief Justice.
And for passing of the criminal proceedings, the said matter has already been detached from the present case. The assignment was not there.
By the time my lordship matter come
Now
to your lordship, my lord.
My lord.
But the IU my lord sent a intimation, my lord. Reference subject I beg to state that during inquiry at village Rugudi Sahi, Atmalik, it was ascertained that the complainant Maheshwata Sarangi is now staying at Bangalore and serving there, and her parents are staying at Bhubaneswar. Hence, the notice could not be served to the complainant, but on contact her mother mobile number, she stated that they had compromised the case. On further inquiry, it ascertained that case is now pending. The Honorable Court, SGM Atmalik at a.
So there are two matters.
You also want to what stage the case is pending? Upper stage.
Matrimonial dispute.
But she has already received 20 lakhs. as per matrimony,
What about separated?
my lord,
Mutual.
my lord,
All right. Where is your client?
my lord.
Where is your client?
Counsel person direction athile.
Why should I give direction? You are accused, you are coming to the court for quashing. You should be there.
My ballot, as my lordship was pleased to quash, that is why I am not for.
Yes.
Object to quash, but as because it was not assigned, it was kept.
It is set aside. Which
Mine.
one is set aside?
That is a proceeding is here. That is for issuance of visa to go abroad in connection with service.
Then
That was allowed.
Which now I have to decide this matter.
3172 of 2019.
3172. This is essentially quashing of the entire process.
My lord, my lord.
So then you have to call, bring him tomorrow.
I can
Tomorrow.
call only husband
Husband.
because wife is
How many of them are there? Petitioner? There are 3 petitioners.
Yes.
Ah.
Father, mother, and
Father and mother, and all of them, they can appear through VC. What is the problem?
my lord.
Ask them to appear tomorrow. VC
My
2
lord.
o'clock. Huh? VC tomorrow.
Are they, that may be noted.
Huh?
The instruction, my lord. That will be kept in record, my lord. Also.
Right. The IAC Automalik,
Yes.
notice was issued to opposite party number 2.
My lord. That could not be served, my lord. The
Notice
since
was
you have
issued to the opposite party number 2, but the notice could not be served. Could not be served. The
complaint, my lord, since he residing at Bangalore, serving there. That is in the instruction, my lord.
by the order dated 8/1/2024, the IIC Automalik was directed to contact the opposite party number 2. Opposite party number 2. Opposite party number 2, and place a report before this court. Pursuant to the said order.
And also directed to, my lord, the what about the status of the
And also directed to obtain the status of the investigation.
no, my lord, case, my lord.
Case trial of
Status of the
Trial.
pending GR case.
My lord.
Status of pending GR case number 406 up to 2015.
My lord.
Pursuant to the said direction, the IIC Automalik White is written instruction dated 21/2/2024 has inter alia stated agenda. The written instruction is taken on record. Let counsel for the petitioner seeks an adjournment to ensure the presence of the petitioner. Leaves the matter to tomorrow.
tomorrow after lunch, my lord.
2 o'clock. Whenever you bring,
My lord, my lord.
I'll take it up.
I'll appraise this one.
No problem.
Pardon to mention, my lord. Item 48, my lord.
We are
And-
in which matter? 49.
48.
48, what happened?
48 will kindly taken on next week, my lord. On behalf of Mr. S.K. Das, my lord, his mention करते my lord.
Non-appear in the interest of justice for the ना non-appear जाए card be non-appear at the request of
Entry, my lord, continue, my lord.
Continue it.
okay.
51.
May I please, your lordship? Your lordship, may I kindly see the order dated 6/2/2024. The same set allegation is 2 FIR, my lord. Let's see.
What is it?
Yes. And my lord, on that date, my
This
lord.
matter can take up tomorrow, my lord. I contacted the IO, my lord. IO served the notice on the OP2. That is also directed me to ask the IO to serve the notice on OP2, my lord. But in fact, my lord, the
Chalo, 10th.
10th. Let's say along with my lord, CRLMC 1160, because it was last 3 occasions it had come along with my lord, but 2 days segregated, my lord. Why I am not, my lordship?
Okay, see the name.
1160. 23.
10th.
My lord, 10.
Okay.
Great.
52.
That's it, can taken out the matter after 1 week. In the
Right.
meantime, I will remove the defectors.
Adjourned. Yes.
53.
Oh, connect time maybe.
Adjourned.
54.
May please, Lords.
Yes.
May please, Lords. In this case, my lord, I have challenged the FIR, that annexure 1, my lord.
There is
I'm sorry.
After the Lordship is directed to file the documents.
My lord, I have applied for, but not yet.
You not got it.
Not yet obtained. I have contacted the advocate of the lower court.
2 weeks.
Fine.
2 weeks.
But my lord, the lower court trial is going on, so that is very difficult.
That is the reason you should expedite.
My lord, because it is, my lord, it is a purely fake caste certificate case. My lord knows very
Fake
well.
or no fake, it has to be
Yes, my
found.
lord, no caste certificate has been issued in my favor.
It's all right. You get it.
My lord, my lord, the final report also clearly says that. Clearly says.
We'll see. File the document. We'll see.
Deposition kariyo. Oblige me.
Yes.
55.
2 weeks.
Not fresh. Not fresh. Where is the memo?
Memo.
Huh?
Sir, memo.
Speak little louder.
Sir, today may file the memo.
Get the memo and come.
Okay.
Okay.
55.
55. Get the memo and come right now. Memo is your withdraw. Withdraw. Memo nahi hai. Yes.
56.
May it please your lordship.
Yes.
Not on the last occasion, if your lordship recollects. This is that case, section 443, I had filed a petition to release my property which has been given by the accused towards his satisfaction of bail, security for bail. Now, that 443 application has been rejected because there is no provision to release that property in my favor.
He is absconded.
That accused is present. He is on bail. That property which he has given for security towards bail is my property. I am not an accused. And on going through the records, your lordship was satisfied that there is a civil miscase which is pending, for which the OPID court is not able to release the property. He's saying that that civil miscase can be adjudicated, then only the property can be released, not under section 443 of CRPC. The case under OPID Act. So there your lordship had opined that that could be targeted, that civil miscase. But Mr. Bhuya is to appear on the other side. He was not present. Yes.
Did they either Vivekananda Swami?
No, Mr. Vivekananda Bhuya, I have informed him. Pass over the.
Bring him.
57.
May I please, your lordship. Your lordship, the petitioner is challenging for passing of the entire proceeding, your lordship, under the compromise. Your lordship earlier.
Compromise, your lordship.
Yes.
What is the allegation?
Allegations, your lordship. She still there. Thereafter convicted.
The allegation is that kidnapped my minor girl. And later on came to know that they were in a love relationship and everything compromised hai jaichi, but elderly persons basiki and case counter case, case counter case. One FIR which was registered by them.
Already that has been quashed. Your lordship, I have annex 2 and 3 respectively, your lordship, order dated 26/6/2023 in CLMC 2138.
That is regarding that is which FIR?
That is PS case number 16 of 2023.
Registered by?
FIR and counter FIR. Registered by the one Pradeep Kumar Barik.
Who is he?
That is OP number 2.
Pradeep Kumar Naik.
Pradeep Kumar Barik. Naik, sorry.
OP number 2.
OP number 2, yes.
Okay. And what about the other this thing? This is one. Charge sheet is filed?
Yes,
your lord.
Where is charge sheet?
May I pray your lordship kindly may direct to both the parties will be present. So it will be.
It is a settlement matter. I can't direct.
Yes.
You have to bring them.
Yes. So
when can you bring? You tell me.
Any day, your lordship. On Friday, your lord.
You bring them.
Yes, all right.
Yes.
On Friday.
Direction means as if the court is forcing them to come.
No, it's all right.
You bring them by their own violation, they will
Yes,
come.
yes, all right,
Friday.
yes.
Okay.
Develop.
58.
The present petitioner is the husband of the deceased wife, and the informant in the FIR is the mother of the deceased wife.
Petitioner is?
Is the husband of the deceased wife, Milords, and the informant is the mother of the deceased wife. Milords, a case was registered against the
Police
present
party number 2 is your mother-in-law.
is the mother-in-law, Milords. A case was registered against the present petitioner for offences alleged under section 498A, 302, 302 and 304B, Milords.
Investigation is still on.
Still on, Milords. Initially,
My lord, earlier this petition was filed 3 numbers of anticipatory bail application, my lord. And at the first hour and second hour. But regarding the bail, my lord, what is the position? I don't
You are
know.
on bail.
Milords, I'm not.
And which affidavit has been filed by the OP number, my lord, and the petitioner, what has mentioned in the petition, my lord, that is each other contradict, my lord. My lord,
Milords,
petitioner
may I be allowed to
Para
submit?
eight-
May I be allowed to submit, Milords? May I be allowed to submit? Then my learned senior can. Milords, after the postmortem report was received, which is at page 30, Milords, may kindly see.
30.
13, 13, Milords.
304B is there.
Yes.
At page 14, Milords, may kindly see. On dissection, Milords has it. Initially, the FIR was registered alleging that the present petitioner has poisoned the wife, Milords.
On
Page 14. Last sentence of that paragraph, Milords. Rupture of right fallopian tube at isthmus with contusion of broad ligament, body of uterus is empty, Milords. Milords, initially it was alleged that the present petitioner had poisoned the deceased wife, after which the PM report
Charge sheet has not been filed.
not been filed, Milords. But at page 15, Milords, there's an affidavit that has been filed by the mother-in-law.
Tell all these things to the police. Why should I watch it?
Milords, there's no
Case
case,
of 302, whatever.
even seeing
Wrong,
the,
right, whatever. There is
there's
an
no
FIR.
case made out against the present petitioner because
Can I go into all this thing at this stage? Investigation is still pending. It's a case of 302 registered. You can tell all.
I would pray, Milords, may issue notice, they let the charge sheet come meanwhile, Milords. It's a case of 2022, Milords.
Don't stress so much.
2 years, Milords. 2 years.
Let it be, but see, it's the allegation is 302. Investigation is still going.
Milords, in face
You
of
have materials, I understand you have materials where no case is made up.
made out, Milords.
Police has to look into it.
Milords.
I at this stage cannot do the police officer's job. A closure report may be filed. I don't know.
Milords, at this stage, can it be pushed to face prosecution in face of the materials?
Annexures which you are filing here
Milords.
are part of the court record, part of the court record.
Milords, I agree.
On that basis, they will file the charge sheet. You are not filing any special document.
Nothing from my side, Milords.
You are relying upon a postmortem report.
Only the police papers, Milords.
Police paper.
Milords.
On the basis of police paper, they have to take the call whether closure report is to be filed or charge sheet is to be filed. If the charge sheet is filed, then you again come.
Yes. One question I ask myself, at this stage, can I be pushed to face prosecution in the face of such materials? The PM report and the
Unfortunately, yes.
Milords.
Because the case is serious. It's a matter of 302.
Milords, it's a case of 2022.
You may say
The police hasn't been conducting their investigation diligence.
to that extent, I can ensure that police has to take a call. Under 173, they can't keep it pending for years.
Milords, may see the affidavit also. They have stated on oath, Milords, that they had filed the present FIR out of misconception after the PM report had come out. They realized that there was no poisoning and in fact there was a rupture in the uterus due to which the woman died. Now, should I be pushed to face prosecution?
What my learned friend is submitting, if your lordship will take to that affidavit, my lord, that will be wrong expression in the eyes of law, my lord, because it is a kind of tempering of the evidence.
The affidavit aside, only the PM report,
yes, my lord.
Milords, only on the PM report, even if I keep the affidavit aside, it's filed in the Court of Executive Magistrate, Milords. Even if you keep it aside, only the PM report makes out that there's no prima facie case against me.
Please go and impress upon the police.
Milords, a case of 2022, Milords. The police hasn't filed charge sheet. I've been facing prosecution for the past
2022, what are you doing? Materials are there, everything is there. Why don't you file the charge sheet or closure report, whatever?
Yes, madam.
I am at the bearing brunt
How
of
much
it.
time will you take?
Yes, madam.
You tell me on 10th. What is the status of charge?
Let them seek instructions.
There,
May
there
keep
you
it
are
pending.
correct. There you are correct. If the material is not there or whatever is there, they should take a call. Whether you file a charge sheet or don't file charge sheet, it is your prerogative. But please tell me on 10th.
Milord,
Please.
I'm grateful. I'm grateful. Milord.
Unfortunately, what to do?
Milord.
I can see that the postmortem report is.
FIR have been filed.
After that, they filed, and the mother of the daughter has filed that
Bill is
affidavit,
there.
Uh,
which is that
But after giving a FIR under 302, you turn around and give an affidavit.
only after the PM report. They were,
I don't know. The PM report might have been manipulated also. Nobody
Yeah.
knows.
Milord, they should have filed charge sheet. Milord, it's been 2 years.
Nobody knows it.
Milord,
So let us see.
we'll wait. Milord,
Okay.
may I pray, Milord, may
10th, nothing will happen.
allow the IA for stay, Milord, till 10
Where is the
interim.
question of stay in an investigation? I don't know. Why are you moving such application?
Milord, sir,
Can the
very
court
well.
say the investigation?
Not the investigation.
First of all, I should dismiss it. The entire
Very well,
petition
Milord.
has to be dismissed.
I bow down,
In full
Milord.
sense.
Very well.
But I am giving indulgence only because of the reason it is a matrimonial dispute. Fortunately or unfortunately, somebody died,
Milord.
and the PM report is somehow in your favor.
Milord.
Let us see the charge sheet.
Milord,
Otherwise,
I bow down.
no indulgence can be given.
I bow down, Milord.
So let us see on 10th.
On
what
10th,
happens.
Milord. I'm grateful.
59.
Yes.
Here I have challenged an order framing charges. Annexure 2.
But revisions are not.
My lords, I rely on 2018 volume 16 SCC
No,
29.
I don't have that assignment.
My lord,
I don't have that assignment.
which one?
Yes.
Revision matters.
My lords, para 37 of this judgment says,
No, that's you are right.
this is a CRLMC, my lord.
Criminal revision is written here.
भूल रहा है criminal revisional लिखा है ये.
Charge framed against the.
Revision you have filed.
My lord,
And rightly, my lord.
in that Asian resurfacing case, para 37, their lordship said that nomenclature is not important. It can be revision,
Why
it
do they-
can be
I know
read.
that. See, to that extent, you will find judgment either side. Whether framing of charge is a final order or.
No, that is what their lordship say in that judgment. What their lordship say, I am just placing before your lordship. Their lordship say, we declare the law to be that order framing charge is not purely an interlocutory order, nor a final order. Jurisdiction of the High Court is not barred, irrespective of the label of a petition.
There are judgment
be it
either
under
side. That will be
397
Both sides.
or 482 or Article 227. So your lordship can.
Within the 70 years of our independence, we are not able to decide whether charge, framing of charge is a final order or interim.
70 years.
That's the reality.
The code has been there since 1860, my lords.
That is the reality. What to do?
Right, man.
Therefore, I am submitting your lordship may issue notice.
Rightly mentioned here, criminal revision.
And a criminal name sheet is written, somewhere it is the revision written. I don't know.
ଆଜ୍ଞା ଏଟା ଫାଇଲ କଲା ପରେ ମୁଁ ଦେଖିଲି ବା 90 ଦିନ ପାରି ହେଇଗଲାଣି.
That's the reason. Limitation ପଳେଇଛି ନା ସେଥିପାଇଁ designed simply just examine and notice. Issue notice. Whatever objection you have, you take.
May I pray one thing? A short date may be fixed, your lordship
Short
may
date.
say till then, let them not proceed.
And I have to see whether it is.
Exactly, but till then, your lordship may fix it to next week.
319 petition that has been allowed, my lord. The petitioner appeared before the court, my lord. Charge frame, my lord. He has not challenged the framing charge, my lord. And he also
That,
he is innocent.
that Mr. Ragada is not.
trial.
Why I appeared is this.
I'll not.
My lords, I had challenged that before your lordship. Your lordship may look at the order sheet, your lordship will find it. My lords may look at page 11.
11.
Aye. Order dated 3/8/23 ଗଜୁର ଦେଖନ୍ତୁ ରଗଡ଼ ବାବୁଙ୍କୁ ମୁଁ କହୁଛି ତାକୁ ଟିକେ ପଢନ୍ତୁ
In a case,
କହିଲେ record is put up today being advanced, accused namely so and so surrendered, produced his ID proof, executing fresh vnama in favor of so and so and associates. He filed surrender. Copies are surrender is allowed, taken into judicial custody. Recall NBWA issued against him. Counsel for above named accused filed a petition praying to release him on bail on the grounds stated therein. He also filed certified copy of order of Hon'Ble High Court passed in CRLMC 1786 of 2023, wide order dated 3/7/2023. I had come up before your lordship challenging that 319. And this court, my lords, said that I am not inclined to interfere. CRLMC is disposed of, granting liberty to petitioner to consider the bail application on its own merit, having regard to the principle of parity, because co-accused have been released on bail in the meantime.
No, that is not this. Charge matter came basing on the evidence of the witness. That has not been filed by my lord.
Basing on the evidence of witness.
Those witnesses, my lord, the deposed against him, 319 allowed, my lord. They are evidence. They are evidence of the court, my lord. They have to, my lord, has to file the evidence of the witnesses.
319.
My lord. Basing on that.
You are summoned under 319.
P11, P44, P88
That's
ଆଉ ଗୋଟେ P66 ନା କଣ ସେ ତାଙ୍କର ଏଭିଡେନ୍ସ କୁ ଲିଡ୍ କରିକି ଏ ଅର୍ଡରଟା ହେଇଛି ଏତିକିଟା ଆମକୁ ଦେଇଦେଲେ କାମ ଖତମ
ସଲା ଆମ ଅଛି ନା ପ୍ରାଇସ୍ ଦେଖିବା ଆଉ ଚାର୍ଜ ହବ
ତାର ଏଭିଡେନ୍ସ ଅଛି
File the evidence. File those evidences. Give a short description.
Next week.
Next week. Next week. Next 61.
61. 61. 60.
60, your lordship, extension of time, your lordship, because of extension of time. I have filed an IA to comply your lordship's order. Extension of
What
time.
is this? NBW?
Yes,
Extension
Lord.
of time for surrender.
No, lordship, actually that matter, no case is there in his name.
Yes.
So because of his pulmonary problem, see, he couldn't appear by 15th March. So I am
When do you want? Now,
any day in May, your lordship.
15th May.
Yes, lordship, 15 May is that,
the
yes.
petitioner had moved an application. IA 43. Seeking extension of time granted by this court for him to appear on or before 15th March 2024 on the grounds mentioned in the application. The time is further extended till
15th May.
5th May. 2024 for the prisoner to surrender and again remedy and
Okay.
allowed of the research. Yes. Dispose of. Next.
61.
Lordship may kindly see.
That's it. Here I have filed an application to firm.
It is my case. Your lordship will first hear it.
Of course, sir.
Lordship may kindly turn to IA 652 of 2024.
IA
652 of 2024.
Yes. Yes. Yes.
The order dated.
Yes.
In this case, I am seeking amendment in view of the fact that in the order dated
What do you want?
modification of the order dated 13/3/24 in view of the fact that in that case, that order, your lordship has not mentioned the case number. Case number and the court have been, it is.
Yes. In view I am of the view that we take into consideration wrong pending no case. The proceeding is concluded. I have tried which proceeding.
My lord.
That's clear.
So your lordship will mention in my prayer, whatever my prayer I have mentioned, that has to be incorporated in that order.
That's the only.
My lord.
Right.
I am to the opposite party. This order dated 13.
I submit because this is a separate thing, the other party is a separate thing.
No, what is your objection to the application?
I'm
Wrong, right? There was an order.
My
You
lord,
are agreed to challenge that order.
This order, your lordship, have passed on 13/3/2024 without notice to me.
Which one? Which order?
This order which sought to be modified.
13/3.
13/3. This order, your lordship, passed without notice to me. Now, I have therefore filed an application for modification of this order. I am stating in my application how it will be prejudiced to me. I have limited right of hearing. If your lordship is not convinced with my application for modification, your lordship can pass the order which your lordship is proposing. I am not standing in the way. So what is my objection, your lordship? That's the.
Then I have to decide two modification applications.
My
One
lord.
modification application is that I should
In
incorporate
fact, my lord, I was never been given an opportunity to have my say in the original proceeding itself. And your lordship knows that in Pohla Singh cases where I can file within my right.
What is the order?
Yes.
How it is prejudice?
How it is my prejudice, my lord.
Speedy trial is
I'm
a constitutional right.
I'm just coming to that, your lordship. Now the constitutional bench has taken a position that
You
no
can delay the trial.
no criminal proceeding can be targeted by your lordship. That's the recent 5 judge bench when Asian Resurface has got revisited.
No, that doesn't say that.
Yes, my lord. I have the judgment. Let I am coming. That's exactly is the ratio, my lord. I'm just.
But not the.
Yes, my lord.
What is the prejudice?
I'm straightway taking to conclusion. After that, I will make my.
Yes.
The Constitutional Code, paragraph C.
Which paragraph?
Paragraph C, paragraph 37C.
37C.
It is the conclusion, summarizations of the main conclusion from it.
Yes.
That your lordship filed from the report, page number. Yes.
Right on 37. Okay.
Yes, ma'am.
Subject to that.
Yes, madam. Subject to what we have had earlier, we summarize our main conclusion as follows. Now your lordship come to paragraph C. Constitutional Court in ordinary course should refrain from fixing time-bound schedule for disposal of the cases pending before any other court. Constitutional Court may issue direction for time-bound procedure only in exceptional cases, and the issue of prioritizing the disposal of cases should be best left to the decisions of the concerned court where the case is pending. Now I am coming that what is the fact of the case? The entire representations of the petitioner is not correct. What they said in 2018, this is pending. They are not getting any maintenance and all these things have been placed before it. At least there are 2 proceedings pending before this honorable court. Another observation in that judgment that if Constitutional Court already in session of the matter, then targeting disposal should be avoided. Now, this honorable court in session of 2 matters, one criminal CRLMC at our behest and a criminal revision at their behest. In case, if order of interim arrangement has been passed by this honorable court. This is a fact that has to be brought to your notice, and in the affidavit of the file by the petitioner, unfortunately, in person actually stand. It has stated there is no.
Yeah, I'll see.
No proceeding is pending.
1 minute. You tell me one thing. 2018, a section 12 domestic violence act application was filed.
Yes.
In 2024, I have passed this order saying that dispose it up to within 6
I deeply bow down to your lordship
months.
observation.
6 months with two.
Yes, my lord. The question
in the month of March.
The question exactly, my lord. I am addressing that. The question here that why this delay for so long? That's the question is to be inquired into.
that why this proceeding at the first
Even
place.
if at the instance of them.
Yes, my lord.
Even if it is attributable to them, delay is attributable to them. What is wrong in
My lord,
saying
if-
that it should be disposed of? What is
If
the
your
wrong?
lordship target, then the court will not allow me, my lord, I am a government servant. I have two willing parents to look after, none in my family. Now, my lord, even a 1 day leave I cannot ask for. He will then hastily proceed away and pass an order.
6 months is a big time.
My lord, 6 months, they have already consumed 2 years to examine one witness. On record.
Then I'll further clarify that none of the party will seek unnecessary adjournment.
My lord,
See,
they-
that
my
is
lord,
what I think.
again, that is a catch. Man, unnecessary and necessary. Again, I have based on fact and circumstances. So, lordship, kindly see the order sheet they have annexed. They have the witness PW1 started, did not turn up. The court say if you do not file your evidence affidavit, you will be struck out. At that threat they have filed. Then they did not service the evidence.
Where is your IA? Where is your IA?
My lord, my IA is 790 of 2024.
790
of 2024, to which they have no file, no objection has been filed.
It's all right, but I
I am
understood.
filing.
Get it. These are not the issue to
My
be,
lord, it is unfortunate that such statements are being made unethically, unreasonably, and illegally.
Why,
My lord,
by the way, why you people are not settling? Matrimonial.
Exactly, my lord,
What is going on?
I am ready,
No,
your
because-
lordship, send it to any, yes, sir, I am ready.
My lord, it was sent to,
Yes, my
for
lord, I am
mediation,
ready.
they
Your
refused.
lordship can send it to the
It was
conciliation.
sent for mediation, they refused.
Don't
That is on
fight.
record.
I am not ready to fight, my lord.
After all, it is a matrimonial dispute.
Your lordship knows the pitiable.
A lawyer of your stature can.
Your lordship may record.
Yes, my lord.
statement that
Your lordship
this
knows
was
the
sent for
husband's
mediation.
pitiable condition in these cases.
Either I should
I am
I
ready
should
to.
submit or he should submit. The matter was sent for mediation. They refused to mediate. They refused to consider anything. Thereafter, mediation failed.
No. The report can be
Yes,
filed before before
No,
this.
I will not.
Where in the High Court mediation?
Yes.
And that is
I
pending
will
in that
not seek
proceeding.
any, I will not seek any adjournment because I pray that this matter may be disposed of today. Taking into consideration the length of period, my lord, what my learned friend is saying.
But the mediation it is pending.
They, my lord, no, mediation.
My lord, I'm saying that.
My lord, he says the PW1 is not available. They took 9 adjournments to cross-examine PW1.
It is all ego issue.
Nine adjournments. And they are saying that I am responsible.
It is only ego issue by your client, unnecessary.
As per the
No most question of chance. No question of chance. Let it be taken up whatever legally possible.
that is already.
Why can't see these are matrimonial disputes?
Matrimonial
You can't pull on. Better that you settle.
I always agree, my lord. I always agree.
It is only delaying tactics. The entire process they are taking over.
Then
Let me hear.
Unethically.
Your clients have decided to keep on fighting for years together and nowhere.
That is why I have come up the
Keep on fighting. What can I do?
I'm just submitting. My lord, I am submitting. My lord,
790. I'll take care of your interest also.
No, my lord, what I'm submitting is.
12.5 is very clear.
There is already a proceeding called divorce has been targeted by this honorable court. There is already a proceeding for divorce is targeted by this honorable court.
I don't know.
In spite of that, expeditious disposal. I am the petitioner in that case. In spite of that, and in spite of the effort for conciliations, nothing is coming out. Now, today, your lordship can visualize this. I am under the obligations of this honorable court's order, and there is not a single instance of I am violating any order. This honorable court arranged an interim maintenance of 10,000 rupees, which I am continue to pay, not even a single day fail. That's on record, my lord. That's been suppressed. That's on record. Now, my lord, there are several proceedings pending. Now, I am government servant. And
I don't want to be in this.
My simple prayer.
Lordship can at best say expeditious disposal. I can expedite. And
my simple prayer is taking into consideration
targeting
target may be set.
Targeting will be prejudicial to my
The
interest.
present I is moved by the opposite party number.
No, first I might
I'll take care of that.
my lord.
Opposite party number 2 seeking modification of the order dated what is that order dated
3/24
3/2024 passed by this court, full stop. The operating part of the said order reads as under 13 row say order last paragraph applicable. Para 2. Para 2. Para 2. Para 2. Mr. Rathor, Lieutenant Counsel for the opposite party number 2, submits that the aforementioned order was passed without affording his client an opportunity of hearing.
He is appearing for OP number 1.
OP number 1. OP number 1. He has relied upon a judgment of the Honorable Supreme Court in so and so, so and so. Relying upon para 37.
I am also submitting a judgment.
Para 37C. Para 37C. Para 37, he submits that the Constitutional Court should not target the proceeding pending court. He further submits that the delay caused in disposal of the petition under section 12 moved by the petitioner is solely attributable to the petitioner herself. She submits that she took 2 years to examine one witness.
PW1 and now the
I'm recording his statement.
My lord, then my statement that they took 9 adjournments to cross-examine the.
That also I read.
Lordship, one more sentence can be added there.
Therefore,
One more sentence can be added there. The matter was posted to 20th February. Then it was posted to 12th March. Of this.
I'll tell you one thing.
My lord.
I'll add one more thing. In a matrimonial dispute,
Even
if
today there is
no
a all the time there is a time.
Ego predominantly works. And when very competent lawyers appear from both the sides, it is sometimes it is counterproductive.
Since my learned friend is
Sometimes it is very
insisting,
counterproductive. Right?
my lord,
Saying that
since my learned friend is insisting, let it be kept on record. My objection. Objection, let it be kept on record.
The
Copy, sir.
Mr. Pujari, appearing for the petitioner, have filed an objection to
My lord.
said
To their eye.
application. And application. He interestedly states that it is the opposite party number 2 who took 9 years.
9 adjournments to cross-examine the
9 adjournments before the court.
petitioner.
Before the court below. Confront with that situation, he had to approach this court. And on the approach this court, there are multiple litigations pending inter se party. Several attempts were made at different stages for reconciliation, but in vain. In these circumstances, Mr. Rathor further submits that this court, targeted, he further submits that he has already moved an application under section 13 seeking resolution of marriage. This court has also targeted the paid petition to be disposed of as early as possible. The objection is taken on purpose. The petitioner has also moved an application under application being IA number 652 of 2024. Basically, seeking modification of the order dated 13/3/2024. Mr. Pujari submits that in operating part of the said order, the case number is not mentioned.
Case and court number.
Case and the case particular is particulars are not mentioned. Therefore, he seeks incorporation of the case number and court number in which the said petition is pending. Taking into consideration the submission made at bar on behalf of Mr. Pujari and Mr. Rathor, I am of the considered view that that case, which case,
DB case, PWD.
what is the number of the case?
DB miscase,
26.
DB criminal miscase number 326 of 2018.
Right.
Now pending in the court of the JMFC 1 cock taking, Cuttack. Or any court in Sicily.
DB criminal case number 326 of 2018.
My lord.
Pending in the court of JMFC
One
1.
cock
Cognizance,
taking.
cognizance taking, bracket close.
Cuttack.
Or
Or any court in Sicily may be right.
Or by any court in session of the said matter shall do well to see that the matter is disposed of as expediently as possible, preferably within 6 month period. It is made clear that none of the parties to the state proceeding shall seek unnecessary adjournment. The apprehension of Mr. Ratho that he may not get a fair opportunity to defend the case is unfounded, because this court believes that the trial court will afford a fair opportunity to the clients of Mr. Ratho to defend the case. With these observations, we both the eyes are this. Still, I am saying that you settle.
I am ready even today. Right
Shall
now,
I-
if your lordship allow anybody.
Mr. Pujari,
Only active.
1 minute. Shall I record
Yes.
one sentence that the trial court should make all effort to
It will
see
only
that.
delay, it will only further
My
delay.
lord, what is harm in writing?
Harm, we know how it is causing harm.
Right. And
How
in
it
the
is
stages of the proceeding.
How they are causing harm, we know better.
Needless to say that the looking into the nature of allegation again, since the matter is pertaining to a matrimonial discord, the trial court may take steps to settle the dispute through appropriate mediation if possible.
Mediation once paid, my lord, you could again prolong the matter.
No, I am not directing. May do.
If the parties agree,
If the parties
agree, but
if the parties agree. But try and do it why unnecessary. Yes. Next. 63.
My lord, give some time to file objection, your lordship.
Take as many as time.
My
64.
64, my lord, here I am praying for a partial modification of the condition, that is page 8, to appear before the IO every week on Sunday, some 11 AM to PM. I pray, my lord, I am
Which condition?
page 8, condition number 1. Shall report to the IO once in a week, preferably Sunday in between.
They shall not influence the.
That will be remain. That will be remain. This that I pray.
ଆପଣ କେବେ ପିଇବେ?
Every 4 weeks, alternative 4 weeks to appear.
ଏଟା କେବେ ବୁଝା? ଆୟୁ once in a week.
Answer because I am
Once
from
in a month.
once in a month.
ठीक है. This is the application under section 439(2) of CRPC seeking modification of the order dated 31/1/2024 passed by the judicial magistrate JMFC.
Yes.
JMFC Burville in GR case number 1 of 2024.
And
2024. The
chair case number actually 01 instead of 01.
01
Instead of 01, I have written 10. That may kindly I'll correct in here.
01. The learned JMC, while granting bail to the petitioner, has imposed the following condition. Condition number 1, page 8. Page 8. The petitioner seeks modification of the said condition. Letter counsel for the petitioner submits that in place of the petitioner appearing before the IO every week. Every week he may be directed to appear once in a month, preferably on a Sunday, between 10 a.m. to 1 a.m. 11 a.m.
Till submission of charge sheet I very much.
This much. Um, uh, the modification application is allowed, and the petitioner is directed to appear before the IO once in a month on a preferably on a Sunday between 10 to 12 a.m. with the said modification. And the other conditions of the bail will remain unaltered. Accordingly, the petition is
Obliged. Correction that is all.
Yes.
65.
May I please, your lords? My lord, this is the second journey of the petitioner. Earlier, he had approached page 12 is the, my lord, the condition. Number 3, my lord.
Number
3. He shall appear before the IO once a week on Sunday till submission of charge sheet.
So what do you want?
Challenging that order, petitioner had preferred one CRLMA. CRLMA, there was a direction in page 13, my lord. May I place it, madam?
13.
Yes, madam.
Yeah.
25, 2023.
25.
2023.
13 is something else.
Ordered that. 25.
Yes.
On conspicuous of material on record, the court is persuaded to modify the condition number 3 imposed by BLAPL number 10640/22 on dated once a week on Sunday till submission of charge sheet has been modified as that the petitioner will appear before the IO once every fortnight till submission of final form for the next 3 months.
What do you want?
Thereafter, 1.5 years has been elapsed in the meantime. Till date, my lord, he is not submitting charge sheet.
You want a direction to the police to file a charge sheet?
My lord, it's a case of 22. Another 2 years have elapsed.
What do you want? Modification means.
My lord, he is coming from Delhi to, it's extreme difficult to Raukala.
What is the stage? Are you filing the charge?
Thereafter, once a month, in the event final form is not submitted, within the next 3 months,
that 3 months has also been elapsed.
Then
I want this condition may be waived out.
What condition? The condition, there is no condition to appear. Why will you appear?
My lord, 2 years they are taking for charge sheet.
Bhai, just see, it is
No, the plea they are taking that unless the other accused person would be arrested, I will not submit the charge sheet.
I can't give a direction to the police to file a charge sheet.
No, I am not telling. But
What are you asking?
my lord, he
3
is
months is left, you don't appear. Who stays to appear?
my lord, he is staying at Delhi. Unnecessary, it is creating harassment.
What harassment? There is no direction for you to appear before the police.
No, once a month in every final form is not submitted.
No.
Thereafter, once
a month in the event final form is
not submitted
within the next 3 months.
3 months ends.
After 3 months, nothing will happen. 3
Is
months is left.
not also submitted. My lord.
No, who stopped?
My lord, give that observation. Objection.
If you want a clarification of that order, go to that court. Somebody else will pass that order.
No, my lord may pass.
I can't clarify somebody's order.
No.
What is this? Very simple. You simply withdraw, don't invite problem for you. Or otherwise, go to that court. I can't clarify somebody's order. Don't do that.
My lord.
And simply withdraw.
My lord.
Simply withdraw. हम 3 मास पर आपण जीवा दरकार नाही.
नाही. ସେ ଜିନିଷ
ଲେଖା ହେଇଛି 3 ମାସ ପରେ ଯିବେନି.
3 ମାସ
ଆପଣ କିଏ ପଚାରୁଛି?
ସେ 2 ବର୍ଷ ହେଲାଣି ଚାର୍ଜ ସିଟ୍ ଦଉନାହାନ୍ତି।
ନ ଦିଅନ୍ତୁ ଭଲ।
ଆଜ୍ଞା।
ଆପଣ ବେଲ୍ ମିଳିଛି।
ଆଜ୍ଞା।
A condition was creating problem. After 3 months you need not go. Let them take 5 years. How does it make? Be happy.
Pardon to mention, disturb your lordships, my lord, Mr. Bhuyan is there, that matter.
There my name was not reflected. So I have not brought the file. The question is that
when do you want?
Next week or
Next week, 56.
May we pardon you, Lord?
Yes, his name should be reflected. PID. 16. OPID.
Maybe.
There are another matter also, OPID. आज इतने लग रहे ना पासवर्ड नहीं आउ तो अच्छी अपन ना अच्छी नहीं I don't know.
Maybe
Item 123.
Every matter I'll take. I'm not taking password because a senior counsel has come, so therefore I am tentative.
Yes.
Otherwise, please wait. Because he is otherwise also very busy. Getting him is very difficult. And he kept on searching since morning and got it.
Yes. On my toes.
Yes, next.
After lunch.
After lunch.
Two 94, 323, 313, 379, 470, 490 Here the allegation is that the informant is married to the elder brother of the petitioner. And
What is the stage of trial?
trial,
Stage
my
of investigation.
no, my lord, charge sheet has not it.
So let it be investigated.
My lord, here the question, my lord, there of how your relation they have balanced. And the allegation has been in 2007 the marriage has occurred. And 2023 the FIR has been filed. 498 my lord, to 376 2N.
In fact,
Marriage was
anticipatory action
2007,
were
my lord.
rejected.
To 323 has been filed.
376 2N is there.
My lord.
And the investigation is going on.
Anticipatory action was
File
rejected.
is registered in 2023 May.
See, your lordship, the allegation is that 2007 the relationship starts.
Maybe,
And
I don't know whether what will be the charge sheet, whether they will drop any.
well, here there is no promise of marriage question does not because she is already married to the elder brother of the petitioner. That is
Just see your
accepted.
petition, accept a copy of FIR. There is nothing. How can I quash like this? Allegations are serious.
Well,
May be wrong, may not be wrong.
well, here the case is no case is made out because your 376 2N says relationship for
Come
the
after the charge sheet.
your lordship. Charge sheet quashing after the charge sheet manner. Then
On
the
what
question,
basis
then the
I-
apex court says
on
that
what
it
basis I can quash it?
your lordship, then the apex court now says that it is go for discharge of the.
By accepting your oral statement,
My lord,
how can I quash the
no,
FIR?
no, why the
Allegations are such.
your lordship so for the FIR the contention of the FIR.
However, the petitioner seeks to withdraw this petition to approach this court at appropriate stage. Appropriate stage with this liberty, the petition is dismissed.
Your lordship may issue notice.
No.
Because the compromise scope of compromise.
No. Please. Investigation is 376 2N
2N.
is there.
2N.
Just now FIR is filed and you want quashing. And
You know, see,
what
FIR
is the next year? Only one FIR.
My lord,
Keep quashing.
FIR is after your lordship
See, you
50,
can't
16
stretch
years.
482 to that extent.
You know, see, intentionally, at least Bhajanlal case will your lordship come because after such a delay to up.
If you apply Bhajanlal with this case, then it has to be dismissed with cost. What do you want? Shall I apply Bhajanlal?
My lord,
Shall I apply
no,
Bhajanlal?
my lord, the ratio I am telling, my lord.
What is
Otherwise, when
ratio?
there is no premises, here premises is made out. Anticipatory
What
action
ratio?
rejected.
Only FIR is there at this stage. Investigation has not completed. Allegation is 376 and many offenses are attracted. How can I quash it? Yes, next 14.
14.
14, my lord. Here the allegation is under section 376 2N and 4.
45 my lord.
Yes, next 20. 35.
Quashing of the criminal proceeding on the ground of compromise. And the petitioner and the wife has come, but due to health issue, the complainant did not come today. And kindly adjourn to 23rd or 24th.
24.
On that date, he will.
24.
Problem.
67.
May it please your lordships. Lordship may kindly see the order dated 21st of February, where lordship directed to take instructions regarding the sanction for prosecution. May I reiterate your lordship's memory? Well, this allegation under section 276B, failure to deposit the tax collected at source within the stipulated period, that is under Rule 30 prescribed. Now, there has been delay of only 5 to 394 days. It is less than 1 year. Well, as for that reason, I was asked to give an explanation. Now, the petitioner before lordships was a sick unit and went to the NCLT. That order of the NCLT is also there. That is Annexure 4 at page 235. Again, this order was challenged by another financial creditor. That was dismissed and the order of the NCLT was upheld. Well, thereafter, only on 13th of December 2018, the management was handed over. Now, my lords, after the management took possession of the plant, well, there was immediately imposed because the COVID, that is from 20 onwards, this relates to the assessment test 2021. Now, 1920 is the financial year, my lords.
Now, what is your instruction?
Your lordship, in this case, the fact is that total amount of TDS involved was more than 5 crores. And when the notice was issued to him, first notice was issued on 28/2/2022, no reply. Then 13/5, another notice was issued, no reply. Then 18/7/2022, he take 15 days time to reply, but no reply. So we take action on, again, we pass an order.
No, you are escaping one thing.
Similarly,
Kindly
let me say something.
Notices were issued to you, why have you not explained?
No, I have explained, my lords. Lordship may see, is not clear on the instructions. Annexure 7, copy of the
Have you filed counter?
Yeah, lordship, we have already filed the counter.
My lords, that is not the reason. Your lordship will take the order rejecting my explanation. That straight your lordship may kindly turn to page 276, the rejection
Have you now deposited the
tax with interest? Yes, 5 lakhs, how much that is
what is the
admitted.
impact of IB code order?
IB code order, my lords, the
Moratorium operates.
Yes, it is
The
an
lordship-
operation. Now, just a minute. You are not allowing me. Please wait. Lordship will see the order of rejection. I will just take your lordship's 2 minutes. Only 2 minutes. How it has been rejected most arbitrarily. Page 288. My lords, there is a clause, section that is 278 AA, which came into effect from October 2086. That says that there cannot be any prosecution if there is a reasonable cause in making the payment. My lords, here, what more reasonable cause? And my lords, Jharkhand High Court decided against which the revenue went to the Supreme Court that SLP was also dismissed. Now, what the Jharkhand High Court said, that if there is a reasonable cause, 278 AA, which came into effect from 1986, you cannot prosecute him. My lords, may kindly see page 288. I am giving, taking your lordships to para 8.
Yes.
Assessees did not carefully consider, full stop, the financial year 1920, that is corresponding assessment year 2021. In the year of consideration for this sanction for launch of prosecution, as COVID restriction measures were imposed during the month of March 2020, as the delay in remittance is not limited only to the period after pandemic, restrictions were imposed, and as the assessee has not been able to submit copy of any circular notification granting relaxation. My lords, if any of the limitation period regarding remittance of TDS sum covering the various period of delay for the relevant financial year, the explanation of the deducted assessee for late remittance ascribing COVID restrictions measures as the cause is not acceptable. Now he rejects. But fact is, there was a COVID and my factory remained closed from time to time. And that also I have given in my explanation. That also first time taking your lordship to the rejection order. Then, on a comparative basis, assessees placed in similar situation as hence the assessee deductor submission is not on the point not accepted. The other reason, that is NCLT resolution approval, is also not relevant to the period for which the instant prosecution proceeding is concerned. The deducted amount, once tax has been deducted from payment to be made to the party or from whom or from the amount credited to the party's account in the books of the assessee, the deductor is duty bound to remit the sum so deducted to the central government account. No dispute about that. The question is, where is the, I'll take your lordship to a circular issued by the department also. The explanations mentioning the reason for delay therefore do not constitute a reasonable cause as contained in section 278 AA of the Act. Due diligence needs to be exercised by the assessee deductor for remittance of the amount which duly belongs to the government. Once the amount has been deducted from the compliance pattern of the assessee deductor, it is observed that substantial delays are noticed in respect of remittance of TDS amount for the financial year 18, 19, 20, 21 as well. Delay in remittance deprives the government of the funds which generally belong to the government and also results in undue delay in granting credit to the person.
The delay is to what extent?
15 days to 394. Whereas the circular of the their own circular, lordship will see, and cases being investigated by CBI, police, enforcement directorate, or any other central government agencies, or the assessee has enabled others in large scale concealment of.
Okay, it's all right. You tell me what you.
Your lordship, in this case, the discrepancies was from 15 to 394 days, and as per this circular, it is more than 1 year. It is 12 months. Let him go to the trial court and appear before the trial court and says the reason of delays and issue it and submit a discharge certificate accordingly. And
no.
Why this exercise?
No, I cannot face it.
Our courts are so burdened.
Yes. And when there is a
COVID was there, there is no denial of that.
Your lordship,
Yes.
COVID started on 19th, 20th March of 2020.
March 20. Yeah.
And the financial year was only 10 days. Your lordship.
I have given
Total
in my
periods was
I have given
only
in
10
my
days
explanation.
periods cannot be taken
And
into consideration of whole
in
whole year.
addition to that,
No, 1 minute. This is the financial year. Which financial?
1920.
1920. Yes.
1920. Yeah.
It starts from 1st April to 31st of March 20.
1st April to
31st of March 20.
2020.
2020.
2020.
My lord.
Okay. And COVID restrictions started
On
So
20th,
March, in March 20, my lords?
March
20,
20,
completely.
20th, 20.
Yes, March 20th, the shutdown and lockdown started.
and then see March it started. On April it was supposed to be deposited.
My lords?
Only for 1 month, sir. Every month he has to deposit the TDS on the 7th of each month. For the March only, that is the time limit is up
The
to
rule
30th.
says, my lord,
This circular says 1 year, till 1
Yes.
year you can excuse.
yes,
It is 390 4 days.
Yes,
394 days. So it's a matter of how many days?
365, it has to be deducted. It's only a matter of,
365.
yes,
29 days.
don't, 29 days.
About a month or so.
And that is no scam. No, yeah. And second thing, my lord, very important. I have not been issued with any pen.
Where is the Jharkhand? Jharkhand High Court?
Yes, yes, I am giving.
Give Jharkhand.
Yes, Jharkhand High Court, the judgment here. And also,
Give Jharkhand.
yes, yes. Lordship may see. It has been affirmed by the, upheld by the Supreme Court.
Paragraph, which paragraph?
My lords. I am just reading, my lords, the operating paragraph, that is page 59 is there.
Yes.
The amount has already been deposited with interest and there is no reason, the middle paragraph, why the criminal proceeding shall proceed, and the criminal proceeding was launched after receiving the said amount with interest. Had it been a case that the case was immediately instituted and thereafter the tax deducted at source, amount has been deposited with interest, the matter would have been different. As such, continuation of the proceeding will amount to an abuse of the process of law. And also our own High Court has also given the same judgment on this prosecution. D.N. Holmes, my lords.
Give me.
Yes, my lord.
Which paragraph, sir?
Paragraph 19 at page 31, lordship may see. The word reasonable we find from the Black's Law Dictionary.
Where is the page?
Page 31, my lords, of the judgment. Then, my lords.
1 minute.
Yes.
31.
Yes.
The word reasonable.
Reasonable.
You find with the Black's dictionary. Then the
My lord has quoted the definition. Then, my lords, lordship may turn to the next page 32. The legislative intent would be well discernible when simultaneously we glance at the provisions of section 201 and 221 of the IT Act, which says that penalty is not leviable when the company proves that the default was for good and sufficient reason, whereas the expression used in section 278 AA is reasonable cause. The legislature has carefully and intentionally used these different expressions and situations envisaged under this provision. Then, lordship will see para 21. It is well settled law that in a criminal proceeding, by merely showing a reasonable cause, the accused cannot be exonerated, and for showing that reasonable cause, the standard of proof of such fact in support of the same is lighter than the proof of such fact in support of good and sufficient reason. Then, lordship, they have relied on the judgment. This honorable court has relied on the judgment of the Madras High Court. I'll take your lordship then. Para 22 and 23. Coming to the case before us, the prosecution has been launched against the petitioner for delay in deposit of the collected TDS for the same financial year, 2021. The collected TDS was admittedly not deposited with the central government by the due date. The petitioner had failed to deposit TDS within the time stipulated, and as ordained under provisions of the IT Act and rules, they have deposited the said amount in phased manner, with the delay in making the deposit, which begins with 31 days to 214 days. It is not in dispute that the petitioner have, by the time of consideration of the matter as to launching the prosecution for such delayed depositor has deposited the entire TDS with interest, as they were able to pay as per the statutory provision for such delayed deposit. The collected TDS with interest as above has been accepted and gone to the exchequer, when by then no loss to the revenue was standing to be viewed. COVID-19 has come as a novel virus and DG is resulting in a pandemic war for the world.
Okay,
Then-
I understood.
Yes.
Lordship, let me verify both the decision and 1 week time maybe.
What 1 week? I'm reserving the judgment. You,
Well-
if you want to have small prosecution unnecessary, it is clogging, And see, the idea is the exchequer should not lose the revenue.
Yes.
You have accepted it. And it is delayed, so therefore the interest has to be paid.
Interest
They have
has
paid.
already been 5
So
lakhs.
there is
of-
the criminal mention.
Yes.
Here. There is no criminal mention here, sir. So these are statutory provisions, sir.
Yes.
And you have said 1 year. The circular says 1 year. It is a delay of
45 days.
29 days, rather. 29 days.
Yes.
And for that period also they have paid the interest.
Yes.
If it is huge delay, intention is very bad, and consistent defaulter and all so many things. That is not the case. And say they have suffered NCLT proceeding also.
Yes, madam.
In
NCLT
those kind
also.
of, see, NCLT proceeding they suffered, COVID they suffered.
Yes.
Thereafter also they paid somehow, marriage
Yeah.
money and paid.
Paid.
You should be happy on that.
Much obliged.
Okay. Judgment is ଆପଣ ଯଦି କିଛି ଦେବାର ଅଛି ବୋଲି ଦେଇ ଦିଅନ୍ତୁ.
Thank you. Obliged.
66.
Yes. Yes, sir. Mr. Das.
May I please yours? A government employee, he has been victimized at the behest of the evil intended person, my lord. A government employee, special land acquisition officer, he has been victimized at the behest of evil intended person, my lord. Similarly, 2 cases have been initiated against him. After that, investigation, they have submitted the charge sheet and kept upon the further investigation. In that period, my lord, a department proceeding has been initiated against him. During course of the department proceeding, thereafter I will come to what is the duty of mine. During course of department proceeding, the marshalling officer is the investigating agency and produce the entire document. And that period, my lord, it came to light, there is no allegation against me. Because only my duty is that to the extent I have the after field verification by the RI and other designated person, government employee, they have to submit the entire document. I have to credit the amount which they have entitled for the same. My humble submission before your lordship.
Where is the charge sheet?
My lord.
Where is the copy of charge sheet?
Whether charge sheet is submitted, that is not known, my lord. FR 2021. After registration FR, they have filed this case, my lord, in the year 2021, my lord.
Yes, yes, my lord.
I have to take instruction of whether charge sheet.
Where is the charge sheet? Charge sheet is there or not?
At the initial stage, he has filed the application, my lord, for crossing of FR.
I am submitting before it. Similarly, 2 cases, 482 application has been preferred this one by the present petitioner before this one court. This one court was 1 cases and that he has been exonerated from the said offences. Same offence, 2 person, same offence, and he has been exonerated. That copy, my lord, I have got that copy.
You have not filed anything in this.
My lord?
You have not filed
Except
anything.
FR, nothing.
Just, my lord. Otherwise, your lordship may can be next week any day. I will file the entire judgment.
File it.
My lord, my lord. It will
By the time you just teach what is the position of
My lord.
My lord.
Yes, next. 67.
67, 68.
Along with that judgment, my lord, which has been exonerated.
Everything.
Well,
Lord.
Another thing, one thing, my lord, your lordship
But
already
2 is
directed to the
but
state
2
council to produce.
But in the 2
And-
time may given, my lord. 2 is administrative.
ठीक है. And to produce whether any sanction has been made. No sanction has been obtained.
Date?
My lord.
Data.
Obliged.
2 years. Interim order to continue what happened. Yes.
My lord, the petition, your lordship, the petition is challenging
Who is
the,
appearing for opposite party now?
nobody is coming. Last date also, nobody came. The petitioners are the in-laws, your lordship, and the DV case is Mr. I am challenging that DV proceeding because being the lady member also that they cannot be respondents as per the DV Act. and they are not,
Let's see, service, opposite party number. So it's not complete.
No, it is not returned. Item delivered, service completed. Service completed, you will deliver. Service completed.
We'll take it up next week, let us see, service complete, somebody may come.
my lord,
Somebody may come, otherwise you will take.
interim order to continue. with this.
Entry want to come. 2 weeks. they will.
The last date of hearing also nobody came. Therefore, your lordship has kept it today.
नहीं, Manas Rao, 68 na?
68 Manas. Yes, sir.
No, Manas Rao, you can't. His name is not reflected.
This one.
Huh.
Item 68. Manas Rao.
His name is reflected. Mr. Manas Ranjan Samantara is appearing.
Last date also he didn't come turn up. So therefore, your lordship had kept it today.
What are the proceedings? Despite Mr. Manas Ranjan Samantara has entered appearance on behalf of opposite party number 2. However, he is not present today. Therefore, in the interest of justice, matter is adjourned. It is made clear that in the event Mr. Samantara doesn't appear on the next date of hearing, the matter will be taken up on its merits without further. It shall be taken up without further adjourning.
Interim order to continue.
16. 16.
This is Vagu 2 weeks per.
69.
Interim order to continue.
Interim order to continue.
May it please your lordship.
Yes.
My lord, here the petitioners are prayed for quashing of the entire proceeding, my lord.
Yes.
Because all are friends, my lord. 2 are minor and two are in their early 20s, my lord. There is a dispute, my lord, while they are watching opera, my lord, a disturbance was created. And the allegation is that the minor son of the informant
Investigation is still on.
Yeah.
Investigation is on.
Investigation is on.
307.
My lord.
Let it be continued. Let us see what is coming out.
Let it lie over, my lord.
Simply adjourn for 3 weeks. But why you withdraw it if the charge sheet is filed, then you come.
There has been compromise between the parties, my lord.
Compromise, then go and tell the police they will file. See, the petitioner.
As 307 is there, my
The
lord.
petitioner, I just give. The petitioner is petitioners, na?
Petitioners, sir.
The petitioners have filed the present petition seeking quashing of the FIR number so and so, so and so. Okay. The investigation is still on. Learned Counsel, Mr. Rao, the Learned Counsel for the petitioner submits that the parties have in fact settled their dispute. This was their students,
Students.
The opposite, the informant and the opposite party number 2 and opposite party number 2 to 48 years. Student what I.
The petition, I am not.
Father of the victim.
The opposite party number 2 is the father of the victim. Victim, full stop. The petitioners and the son of the opposite party number 2 are the friends. And due to misunderstanding, the alleged incident happened. I am not inclined to interfere the matter at this stage. However, liberty is granted to the petitioner to cooperate with the investigation and apprise the aforementioned fact to the investigating agency. Hence, with this liberty, the petitioner is disposed of.
Obliged.
Tell the police.
Obliged, my lord.
71.
May it please your lordship, I appear before your lordship on behalf of Mr. Sadangi. He is in bereavement
seek some time, 1 week time.
Okay.
73.
And please, interim order.
Entry mode.
I am appearing for opposite party.
You have objection?
Mal.
Objection?
In this case,
Which one?
71.
Do you have objection?
No. So far time is, rather I need 2 weeks time.
Okay. Counsel for both the parties jointly keeps adjournment, matter is adjourned to such and such a entry mode to continue. Yes.
73, my lord, I am for the OP. And the lordship is directed last occasion to file counter not ready, my lord. I need some more time.
70?
73.
What happened? 22? 72?
71 is already adjourned.
Already adjourned. 73. I heard. What do you want?
73, I am for the opposite party, my lord. Lordship's last occasion, lordship says directed if any petition filed, the matter may be adjourned. But some time I required for filing the counter, my lord.
Counter. Then counsel for the opposite party seeks time to file counter. Let him file the counter within 2 weeks. And arrangement.
Interim.
Interim order.
Interim order, no, sir.
Yeah, interim order. Petition is, order was for adjournment.
The interim arrangement, interim arrangement is has been same arrangement.
Same adjournment. My lord have right order dated 27/2/24 has directed that land council submit that he would be moving appropriate application before the court below for adjournment. If did so, the same may be considered.
In the meantime, he may the petitioner may move appropriate application before the court below for adjournment.
Obliged.
Yes.
74.
74, madam.
74, your lordship,
Yes, I am-
may be pardoned. I am on BC. Your lordship, I am on behalf of Mr. Nayak. He is out of station. I am praying for 1 week time. I am for the opposite party.
Correct. Opposite party number 1.
2.
Opposite party number 2 seeks 1 week for an adjournment for 1 week. The request may be adjourned to such.
Sole opposite party. That's
Sole opposite party.
sole opposite party.
Yes.
Well, let it be 2 weeks after that.
2 weeks.
Interim order
Entry continue. Yes.
75.
Order dated 3/4 may kindly be seen.
Huh?
Huh? 13/3 order is
Small variance. Taking up next matter, 123, I may raise let some other tailors, some difficult.
123 note kori rakhiye. No,
Great.
13/3 order may kindly be seen.
13/3. Okay.
13/3 notice was issued, none has appeared.
Opposite party number 1. Service.
Notice was sent by special messenger. Special messenger ଯାଇଥିଲା ନା note ରେ କିଛି ନାହିଁ।
Service.
Complete. Let us read next week on Korea.
I pray, Mother.
Purpose to the order dated 13/3/2024. Notices were issued to opposite party number 2, which has been duly served, but none appears on behalf of opposite party number 2. In the interest of justice,
Notice was against OP number 1.
opposite number 1.
May I pray, my lord, there is an IA. Execution case is there. Let's
Mr. Pujari, land counsel for the petitioner submits that the execution petition is execution petition filed by the opposite party number 1 is proceeding. Therefore he seeks indulgence of this court. in view of the fact that the matter is submitted before the court, Mr. Pujari, petitioner may move an application before the court for an adjournment. If such application is moved, the same can be favorably considered, owing to the fact that the matter is submitted before this court. Hmm.
76.
I please your lordship.
Yes.
Lordship, on last occasion, you have directed, are you willing to pay the compensation?
Hmm.
So we have tried to contact the petitioner as it is a 2011 matter. We could not contact him. His phone number and other details are not there with us. And pray for an adjournment. So
Chitra, how many time you will keep on adjourning this matter?
No.
Tell me in the on merit spot. 2023 twice it was listed, 24 it is listed. What is the on merit? You tell me. What do you have?
merited the lordship, a check was issued for 65,000 rupees. In the notice, the check amount and check number, the mandatory notice, in the
Have you replied to the reply to the that notice?
no, your lordship.
Then
Thereafter, the PW3 who was examined, he also stated that I had asked to stop the payment of the check because I had intimated him regarding missing of the check. Who is the branch manager of the concerned branch? I have intimated about my missing check, and I had also during the trial also it has come that my signature is being manipulated. That also.
have you filed an FIR?
No, that's why I'm telling you. There was no valid legal notice. There's also not come that the outstanding amount, there is some legal liability to square up the debt. PW3 himself admitted in para 11 that on 16/12.
PW3?
PW3 is the branch manager who was examined. Brahman.
Who is the informant here? Is anybody is appearing?
Informant is Uttarayani shoe store.
Anybody is appearing?
He is not appearing.
Nobody appears. I think the complainant is also not interested. Complainant is also not. Notice जाएगी. Notice revision notice पाई नहीं. Notice चाहिए थी बाबू. ऐसे थोड़ी notice नहीं.
Notice. I don't remove the effect.
ठीक है तो NCR मंगाई थी notice चाहिए थी तो वही.
Stay fine. 1-2-2001.
Stay of realization of balance amount of compensation. Or सभी चीज देखो. नोटिस चाहिए थी भाई. देखो issue notice. Issue notice 2011 notice was issued. Third, admit, call for LCR, issue notice, requisites for the issue of notice to opposite party number 2 by registered AD, be filed within 3 days. Requisition not filed. Requisite file की नहीं? हाँ भाई,
Repeated दवा था ना, when the order has been completed.
2011 matter.
बस तेरे के बेटे खुशी होती है, file नहीं. On that ground, I'm dismissing it, okay? जो होगा दिखी जाएगी. ठीक है? On the ground, देखो. The notice was issued to the opposite party. No, the present case is arising out of a conviction and sentence passed by conviction sentence by. Tell me.
Conviction sentence by GMFC Banapur.
Banapur, whereby the petitioner is was convicted for offence under section 138 NIA, and the sentence of what was the sentence?
1 lakh rupees and 1 year simple imprisonment,
1 lakh
which was upheld by Learned
नहीं,
additional.
नहीं, 1 lakh rupees with 1 lakh rupees
1 year simple imprisonment.
imprisonment to award. The petitioner approached the appellate court challenging the said order. The appellate court
Additional session judge Khurda.
the additional session judge Khurda, कौन कला जाए?
By say they held the reduced the sentence from 1 year to 1 month.
By its order dated
16/12/2010.
16/12/2010, reduced the sentence to
1 month simple imprisonment and compensation amount is the same, 1 lakh
1
rupees.
month simple imprisonment, and whereas the compensation amount of 1 lakh rupees was maintained. The petitioner has now filed the petitioner has filed the revision instant revision petition. Instant revision petition on 3 ना कहते 8/2. What is the date?
14/1/2011.
नहीं 14 नहीं यार 08 है. देखो यार ये ज्योति just show me the first order. First order this 1/2/2011. On 1/2/2011, notice was issued to the opposite party number 1. And the petitioner was directed to file requisites. Subsequently, on 1/2/2011, petitioner was enlarged on bail, enlarged on bail. And the stay and the court also stated the realization of balance amount of compensation that was passed in ICC case number 17 of 2006. It appears from the next. It appears from the record that after these interim orders, the petitioner has not filed requisites for effecting service on opposite party number 1. The matter was pending since then. Eventually, the matter was taken up on 13/10/2023, wherein the land accounts for the petitioner sought adjournment. Again, the matter was taken up on 24/11/2023, and the land accounts for the petitioner sought for an accommodation. The matter was adjourned to 2/4/2023. On that day, also, the petitioner sought time. Today, when the matter was taken up, the petitioner speaks for that time. But however, the fact remains that the petitioner, although has been enjoying the interim order since 2011, but has failed to file the requisite to effect service on the respondent. Therefore, the present division petition deserves to be dismissed for non-prosecution. Accordingly, the petition is dismissed. The interim order part earlier stands vacated.
Non-prosecution also non-compliance of
Non-compliance of the order and stand vacated.
Right.
चलो आगे जाओ.
77. From 77 hearing matters, my lord, I have to say something, my lord, because my lord, today morning I have heard some of the lawyer friend of our bar association. that in place of their non-appearance, my lord, the Hon'Ble court asked the registry to issue notice to them, my lord. They have stated that instead of noticing to the council, notice would have gone to the parties, my lord. For that is
No. See, the procedure is if
They
somebody
have-
is appearing,
my lord.
somebody has already been engaged, it is the duty to come to the court. If
My
it
lord,
doesn't come, court notice means it is not
Since
notice.
they have stated that since
it is-
judicial order passed, for that is
No, it
Neither
is
of them,
not.
madam, saying-
Yeah, this is the procedure.
my lord.
Procedure is, I am not asking for explanation why you are not appearing. It is a notice
They-
to you.
they-
Your matter is listed, please come.
They're thinking that notice.
No,
Hence-
that's not the idea. Idea is, that's the procedure.
In order to speed up the cases, disposal, my lord.
Ah,
For that is
so that
lordship.
it is-
On good faith,
notice
the lordship
notice
issuing notice, my lord. But in fact, my lord, some of the lawyers friends told me in the morning that
If the lawyer feel like this, what can I do?
No, I also told them that on first
It is not a- it is not a
on
notice
good
that
faith,
you
on
don't
good faith, the court issuing notice.
No, this is the procedure.
My lord.
Because you have been interested with the case by
My
the
lord.
client.
My lord.
If the matter is taken up, it is a 2011 matter.
Duty bound to come.
It might have escaped notice of the lawyer. So therefore, once you issue notice, then he will come and appear. That's the
They
idea.
are saying that in judicial. But
They are at liberty to take anything
Well, that's it.
in whatever manner. This is the procedure what to do. Either you come or don't come.
My lord, that's it.
Yes.
In the present case, Milots on the last day directed me to verify the custody period, Milots. The hard copy of the LCR has been sent back, Milots. It's been scanned. I need permission from the court to access the soft copy, Milots, so I can see the custody period.
See it now, right now. What was the offense?
379.
379, 2 years in prison.
Milots may call it tomorrow. Any other date, I'll verify
379 only.
again.
Already I'm going to just see tomorrow.
Tomorrow, Milots.
Tomorrow.
Tomorrow.
Tell me, see these matters are pending.
Milots, there are several matters in which the LCR has not called for and they are posted for hearing. In those certain matters, Milots, LCR has to be called for. And not received also. It's
Wherever there is no LCR, we'll see.
Milots.
I think almost all the cases.
No, here, LCR, this present
In
case.
the present case, it's there.
There.
5 more matters today, Milots, in which
Can absence of LCR, my lord, the lordship can dispose of small matters, petty offences are there.
Milots is insisting on knowing the custody period. For which,
For that, this
for that,
Only to convert the sentence to be under.
maybe Milots, they have spent more than the custody period. We don't know unless until you verify.
You check it up tomorrow.
Again. Yes, Milots. Milots may call it tomorrow. I'll verify today.
Urgent to tomorrow. Simply urgent to tomorrow so that he will verify and tell me.
Direct to give us access to the soft copy of the LC.
Please give access.
We'll give a pen drive or something.
What is the procedure? You soft copy.
You have to go to the reproduction and then supply pen drive.
For that, he has to move an application.
No, just go to the reproduction. The court has directed.
I'll put it day after tomorrow
Milots.
so that you can just see.
Let's make direct-
soft copy of LCR is on record. Counsel for the petitioner seeks to inspect the record. Permission is granted to inspect. Permission granted to the petitioner to inspect the record. Leaves the matter on day after.
Milots, I'm getting
Inspect.
copy of the order. Great.
78.
Yes.
May I please the lordship?
Hmm.
Here, lordship, instruction was sought whether the petitioner is surviving or not.
Hmm.
The petitioner could not be contacted.
What effort you have taken could not be contacted is very.
We have sent a letter, lordship, on last it was listed on two.
Could not be contacted, which it will never be contacted. These matters will be pending. Who will get contacted?
The 2011 matter, that's why.
User. Learned counsel for the matter was the matter has been pending since 2011. The matter was taken up for time to time. The last date of hearing, the learned counsel for the petitioner short time to verify regarding the status of verify seek instruction from his client. However, he submits that despite his best effort, he could not contact his client. ये केवंझर PS
police station.
IIC PS IIC केवंझर केवंझर PS
ନା ନା ମାଲଡ଼ ତାର ଆଡ୍ରେସ ସେଇଠି ଘସିପୁରା
घासीपुरा
ଘସିପୁରା ପିଏସ୍ ମାଲଡ଼ କଟାଇଟିଲ ମାଲଡ଼
कुठलं काही
ତାର କେସ୍ ଆସିଲେ
ଘାସିପୁରା
ଘାସିପୁରା
IIC घासीपुरा
ଘାସିପୁରା
IIC घासीपुरा PS of Keonjhar district that is directed to inquire about the petitioner and submit a report on the free copy to Mr. Dabra. ठीक है देखिए वो date you give it to next week 15 days 15 days yes
79.
May I please, your lordship?
79
6 months conviction, my lord.
Hmm?
6 months conviction.
yes
SI for 6 months.
Hmm.
For the offense under section 323,
323
my lord. Concurrent finding. I were not examined and.
I will not examine
No.
I is not examined huh? And what are who are the witnesses deposed
My lord, PW1 is the, my lord, injured eyewitness.
what the doctor says
PW1 injured victim. Our doctor is the
6 independent witness
PW6 is the medical officer. Evidence करा किसी नहीं मौका दे. LCR sent back.
ଆପଣ ଫାଇଲ କରିଛନ୍ତି ରିଭିଜନ ଆପଣ ମଗ ନଥିଲେ କଣ କରିବାକୁ କିଛି ତ ଆସିଷ୍ଟେନ୍ସ କରିବେ ନହେଲେ କେବେ ଏ ମ୍ୟାଟର ଗୁଡା ପେଣ୍ଡିଂ ଥିବ
Pending. No.
କେତେ ଦିନ ପେଣ୍ଡିଂ ରହୁଛି
Maximum punishment is 1 year or fine. Or fine.
ତାହେଲେ ରିଡ୍ୟୁସ ଇଟ ଟୁ ଫାଇନ
सर दियंता लोक तो टर्न अप करनी ଆଉ କଣ କରିବା ସେଟା କରି ଦିଅନ୍ତୁ.
ରିଡ୍ୟୁସ ଟୁ ଫାଇନ ସେଣ୍ଟେନ୍ସ ରିଡ୍ୟୁସ ଟୁ ଫାଇନ ସେଣ୍ଟେନ୍ସ ରିଡ୍ୟୁସ ଟୁ ଫାଇନ କର partly allowed sentence reduced to fine ମୁଁ ଦେଖି ଦେଇଛି
Oblige.
partly allowed you are also happy everybody is happy partly
Well, I'm beg pardon my lord, last occasion
1000 କେତେ maximum fine କେତେ ଅଛି 323 ଦେଖନ୍ତୁ 1000 I think
my lord
1000 fine
506 is there my lord
No,
323 conviction
506 acquitted.
323 conviction 1000 rupees penalty
Last week you also one case.
ठीक है नहीं हुआ that I told that I'll reduce the sentence to 1 year 1000 but when I read the entire file that was a case and acquittal so therefore I acquitted when I dictated the order I saw that the case of acquittal why fine then I acquitted today morning I pronounced that but in your case that will not happen don't worry
No, only my lord, the evidence of the doctor and injured eyewitness, the conviction has been.
No. Injured eyewitness evidence is corroborated with doctor to what to do so therefore anyway fine 1000 yes next
80.
Item 80 kindly taken 1 week after my lord. Some instruction is required, my lord. So
what is the offense
3 years array my lord
3 years right
307 head injury there
offenses
307 head injury there my lord and
head injury
my lord
injury report
head injury
very injury report conviction in the year 99 incident
my lord
what is the age of this accused 31 year in 2011 so see the injury you have that injury report Mr. Raghunath, just see,
My lord,
if the injury the offense can be converted to 323.
page my lord, 15.
Hmm.
Schedule 6 appears to have opined that injuries sustained by the victim Gopal to be grievous by the report exhibit 4, referring to the bedhead ticket.
Yes, see,
Of-
326.
But what happened in this case, my lord? My lord, what happened, my lord? The victim, the injured, my lord, sustained a severe head injury, my lord. He became unconscious, my lord, and remained in hospital, my lord, long period, my lord. And after he returned from discharge from hospital, he could not able to speak anything, my lord. For that, his 161 treatment cannot be recorded, and his whereabouts also not known, my lord. He became perhaps
Informants.
became my lord. No, the injured, my lord.
Injury was not examined.
Not examined, my lord. Due to IO in his evidence stated that since he is unable to speak, my lord, due to his head injury, he suffered, my lord, remain in hospital as the indoor patient for long period, my lord.
Thereafter,
My lord,
evaporated.
my lord. The paragraph 16, IO, my lord, the investigation officer period 7 could not examine, finding him unable to speak till he was discharged from the Cuttack hospital on 26/10/1998. Head injury is there, my lord.
Your doctor's evidence proving. Where is the doctor's evidence?
Para 15 page portal appeal
Para?
para
Trial court you are reading? Or
appellate court
appellate court you are.
my lord. Page 15, my lord.
Page 15.
My lord. Page 15.
Page 15. Okay. Yes. Page 15.
1, 2, 3,
Yes.
4, 5, 6, 7 paragraph pare tapare exit 6 the
Page 15 of page 6 of internal basic.
my lord. The
Investigation, police.
same is also evident from the bedhead ticket of the victim, exit 6. 1, 2, 3, 4, 5, 6, 7, 8, 9, 9.
Victim
Having
having duly
proved
proved
by the assistant professor neurosurgery, Schedule 8. Schedule 6 appears to have opined that injuries sustained by the victim Gopal to be grievous by his report exhibit 4. Referring to the bedhead ticket of the Gopal, it is found from the testimony of Schedule 8 that his assistant had conducted the operation in his presence, and he having referred to the bedhead ticket, exhibit 6, stated that it was a compound depressed fracture of left parietal bone and a underlying external hematoma, and the same can be caused by lathi. Here, my lathi is open upon the evidence it is a grievous nature and injury is not treated immediately, would have caused by death of the victim in a ordinary course of nature, my lord. Serious, my lord. And 3 years conviction, my lord. 1,000 fine also they are.
The conduct of the doctor who has treated has not been examined. His senior was examined.
My senior was present.
The injured is also not examined.
Not examined, my lord. But due to my lord, he is not in a position to my lord, speak, my lord.
Speak that time for the purpose of 161.
For that in 161 not recorded, my lord. He has not in charge sheet, perhaps charge sheet, my lord. Charge sheet not with me, but that has been available in the FR. Whether he has cited as charge sheet witness or not, my lord. I think the IO's evidence, my lord, taken into consideration, he has not been examined, my lord, and not cited also the charge sheet witness.
Even if you bring to 326, it is 10. No, 10 years.
Period of detention is there.
How much you want to go?
पाटा देखी जाती है
Undergone period still.
कितने
ଏ ପିରିୟଡ ଦେଖିଦେବେ କେତେ
99 incident is 99. କାଲି ଦେଖିକି କୁହନ୍ତୁ ମତେ period undergone. If you have undergone
my lord, also my lord, page 23 মানে appellate court judgment my lord, first paragraph towards last my lord, the injured could not be examined as a witness as he was not traceable during the trial.
So therefore, it is a case where we can convert it to an already undergone. You tell me what is the period undergone? Period undergone. Okay. Tomorrow. So what we will do is 3-year sentence we will reduce to the period already undergone. Maintaining the conviction.
My lord.
Okay. Yes.
81.
Yes.
I pay for some time, I misplaced the file, ma'am. Next week, any day.
Misplace the file. What is the offense?
366 my lord. 82. 81.
Sentence?
No, 81 টা আমাকে দিন। 81 আমাকে দিন আছে। আমাকে দিন, কপি দিন।
What is the offense, sir? Offense.
আমাকে দিন।
Huh?
I cannot say so.
This is an ICC case. 138.
138 এর মুভি ওকলে আর হচ্ছে তাহলে মোটর কনসেন্ট নেই। 139 act.
138 case.
139 act. না মোটর নেই এই কনসেন্ট।
In this case also I don't think you have the process file notice was issued in
I received personally on 8/8/11.
Okay.
Next week.
It is 138 case. Next week they do.
I think my lord file is with my lord Smritiranjan Mahaprabhu, he expired in the meantime. It is assets.
Locate the file, or reconstruct the file.
My name may be deleted, my lord, from the opposite party.
No, Mr. Ravada's name may be. He has already given. Yes, next.
Number file
82.
82.
Yes.
Please, your lordship, that the offence is under section 366, but conviction is there, my lord. Last time I prayed for this matter to list this matter on 16. Your lordship allowed the same, but it has come today.
Sorry?
Last time I prayed for list this matter to 16, my lord. So your lordship allowed the same, but matter has come today, my lord. Here the present petitioner acquitted from offence under section 376 and convicted under section 366. Therefore, I think this is a ground matter where there is absolutely no allegation of illicit relationship or a promise to marry, then it can be 366 is not made out. And 4-year sentence is there, my lord. He has already undergone, as per my instruction, my lord, more than 11 months probably. If you lordship, if it to 16, I will better.
Okay, 16.
66.
16. 16. Huh? Yes, next. 83.
83.
I prayed for some time so that I could get the file. In between, I could not get the file from office.
What is
It is
this is again 138 case?
138.
So this should have you served. Let's check it up. Opposite party served or not?
Yes. Notice has been served. They have already appeared in this case.
I for the opposite party. I'm for the opposite party. I'm for the opposite party.
What do you want? What is the check amount?
50,000. I just
60,000.
I saw from his file that it is an amount of 50,000.
50,000, 2011. Why did you pay me?
No, so I will verify. I could not get my file today, madam. That's why.
But you could get your client or not?
No, no contact also. I will try to contact after getting the.
I'll put it day after tomorrow, otherwise I'll dismiss it. For 50,000 rupees, why should this court will entertain?
Thanks, your lordship.
What I'll do is I'll dismiss in for non-prosecution, and I'll simply indicate that notice may go to the petitioner. And once notice goes, then he'll come and contact you. Otherwise, he'll not contact. Shall I do that?
Yes, no problem.
With your consent,
No problem. He will misunderstood me, but it is not a problem.
But I'll record here, sir. But if there is no instruction, therefore I'm dismissing it for non-prosecution. Let notice be sent to petitioner. That way he will contact. Regis, note kar dena. What is your name, ma'am?
Gitanjali Maji. Gitanjali Maji.
M.S. Gitanjali Maji, appearing for the petitioner, submits that he has he could not contact with the petitioner, and there is no instruction. There is no instruction. This case, next program. This case is arising out of a conviction under section 138 NI Act for the alleged dishonor of check amount 50,000 rupees. 50,000 rupees. The matter is pending since 2011. Therefore, therefore, I am of the considering that prosecution, let the notice let the petitioners may be informed by the ministry regarding the dismissal of court in the present petition in the address given in the petition. Please post.
Okay.
84. The notice will go and he will contact you, then do whatever. Yes. 80? 84. 84.
For some time.
Next week. Yes.
85. Confirming judgment, my lord. 1 year conviction for commission of offence under section 325 and 6 months for 324, my lord. The informant and the convicted are the friends. All those are on a feast, and due to some sudden altercation of words, the allegation is that accused feast blow, and the lip of the informant sustained bleeding injury, and one teeth was removed. That is the case.
Where is the medical?
My lord, the deposition copy and medical report is not with me, my lord. I may pray for 2 weeks time.
Then read the order. Can it be converted to 323? Under what is the sentence undergone so far?
That instruction, retrial instruction, I have not that instruction.
You did not ask. You see the record.
My lord.
Some kind of assistance you give, I can, everything will be done by the court. Then.
My lord, let it be possible.
Just take it up.
Yes, yes.
He has undergone little bit. We'll convert it to 320.
Yes, yes. Let it be possible.
And 325. We'll convert it to 323. Yes. 86.
In response to your lordship's order dated 2/4/2024, my lord, I have already filed the requisites, my lord, for issuance of notice to the PW3, that is the informant, my lord.
That case, your lordship, the husband taken the younger sister of the wife, my lord. That case, your lordship.
Father supported.
It is not more, no more a crime, my lord. As for Joseph sign case.
Or that is the lordship.
As for Joseph sign case.
Stated him to bring her, the dispose of here. He has not filed a requisite.
Requisite file for this.
Chalo.
Assist.
Bring it so that we can.
Yes. 87.
Last order was
State to take instruction whether the petitioner earning or not.
Yes.
Status, my lord. This is, my lord, the notice, my lord, sent to the concerned, my lord, police, my lord, but no report has come, my lord.
Yes, pursue it, huh? My lord, next week, huh? Next week.
8 next week. Bye.
On behalf of Mr. Ponda, your lordship, I may ask for an adjournment.
No adjournment, you tell me. The whole case you should have prepared. What is the case? You convicted under which section? 341, 326, 307, 34. Convicted under which section you are charged under that?
24 and 34, I think. 324 and 34.
324. Right down. Taking into consideration the totality of evidence available on the court with regard to the cited decision, I vote for the prosecution has proved its case. Again, remove the two questions. Now they are convicted for 341, 324, 326, 307, and 34 IPT by trial court. And sentenced to
On the page 29, I consider that the ends of justice would be met if the substantial sentence of the imprisonment for 5 years imposed by the trial court for the offense 326 34 IPC reduced the period already undergone by the appellant. As regard to sentence of fine imposed the trial court on the appellants, the same required modification. Accordingly, the sentence of fine 1,000 is enhanced to 5,000 and directed both the appellants to pay 5,000 each towards fine in default to undergo arrest 3 months.
what do you want? Already the first appellate court has given you the
Only fine. Directed the appellant to pay amount within 2 weeks from today after realization of the same amount 10,000, both, my lord, should be paid to the injured. Rather, the liberal, so liberal, the
appellate court. Same thing I would have done it. The appellate court has done it. To be happy. You are appealing for?
10,000, 5,000 is total 10,000.
I don't think we.
Okay, the common.
Heard judgment reject. And pass your. And what is your name? You tell me.
Amit Vikramacharya.
Huh?
Amit Vikramacharya.
Amit Vikram. Heard Mr. Amit Vikramacharya. And if you want to give in anything in writing also, you can give. This is an opportunity to do it. Because see, the appellate court has given you everything. I don't think there is only 5,000 rupees. For 5,000 rupees, you have burdened this court since last 2011. What was 6,000? And see, these people were 35 years at that time, at the time of incident. Incident is 2000. See, that's all right. Okay. 89? Yes.
Okay. Item number 89, LCR is not received.
No, my lord, item 88, let's see. My lord, item 88. My lord, I am holding the other file, my lord. My lord, this petition, my lord, filed by the brother of the victim, challenging the judgment of the appellate court. Sorry, I am holding another file for that, my lord.
Victim is not the petitioner here, but the brother of the victim informed
I'm
the petitioner.
opposing.
Why convicts have, accused have not filed.
High accused had not filed.
Informants have filed. It's all right.
In front of file, it's
Dismiss कर दें.
dismiss or
Simply
dispose of, judgment is.
informant, no? It is to petition is filed by informant. If you let me to work informant. ठीक है? Representation is filed by informant. Yeah, yes. 80, 89.
LCR has not received.
Conviction, you tell me. What is it?
Still,
Under which section?
For petition 380, my lord. 1 year. Both count, my lord, or 1 year each.
457.
And 380.
Yes.
For petition 1 year and 380 so 1 year.
Here is required. Here.
Judgment दिया पढ़ ले भेजो.
हाँ.
Adjournment matter for 1 week I will instruct.
Here the call for the 1 day. Huh? 1 day to call for LCR next week.
Yes.
90.
90.
Yes.
In this case, your lordship, it's a conviction for 7 years and to pay a fine of rupees 2,000 under section 307 and 1 month for 341, your lordship. Though I have been provided both the judgments of the court below by the registry, but there are other things I need to verify from the LCR, your lordship. And I pray lordship may direct the registry to at least provide me a soft copy of this LCR, your lordship. Because here your case, your lordship, FIR registered against 4 persons. Charge was framed against 3 persons. 2 have been convicted, 1 been acquitted. And this petitioner's preferred appeal, which has been dismissed, and for which this present division has been preferred before this honorable court. What about the other?
You have such a thick volume, what I want.
Just now, learned from the court, your lordship.
You want some time?
Yes, your lordship, because time and again he has fled from the custody and NBW issued and remanded to the court. So detention period is yet to calculated, your lordship.
How much time? Next week?
At least 1 week time, your lordship.
Mr. Mahapatra and Counsel MAC is query in the present matter seeks 1 more week to verify the trial court record regarding the period undergone by the convict of the petitioner. Leaves the matter of such.
A soft copy may be provided, your lordship. At least.
Even and he is also permitted to inspect the soft copy of the LCR.
Okay.
91.
AIP Judge. This petitioner has been convicted under section 406 IPC, sentenced to undergo RI for 1 year and fine of 1,000. The co-accused who are charged.
326.
No, my lord, 406 IPC.
406.
The co-accused who were charged under section 411 IPC, he has been acquitted. Co-accused who were charged under section 411 IPC has been acquitted. In the instant case, the fact of the case is that the PW3 has instructed a vehicle to me for repairing. After repairing, I sold the vehicle to the co-accused who has been acquitted. The PW3, who is the owner, who has entrusted the vehicle, he has been turned hostile. And the owner of the vehicle has not been examined. Who is the owner of the vehicle is shrouded in this mystery. In the FIR stated, the one Prabhakar Mishra is the owner. In the IO stated, another neighbor. And that about
Copy not supplied, my lord. The
copy already supplied.
I am dying for a copy. I am doing
Copy the evidence copy the Hajalavi.
Which is the file to be asked. 1 set copy may be given.
One set copy next week now. And if whatever you're saying is to be verified, and in that case, it's a case of acquittal. Co-accused has been acquitted.
Yes, ma'am.
Owner is, who is the owner is not established.
Yes, ma'am.
And the main witness has turned hostile. What is there? Just give a copy. Copy what said. The case of acquittal will acquittal. Next.
92.
92.
Next week. Next week.
Next week.
Not week, brother.
So next week. Well, you are ready now?
Next week.
Next week you will be ready, not now.
Not now for that.
What is the offense, by the way?
325 and
325.
my left.
What is the sentence?
Sentence.
1 year.
1 year.
And 323,
And
4 months.
323, 4 months.
341, 1 month.
1 month.
We will convert it to 323. 323 already undergone. Finish. Come on Friday. Prepare and come.
Right.
Yes.
93.
Yes, three, punished on a 324 IPC, ma'am, only for 6 months. Out of 3 accusable, 2 were acquitted by the trial court. One was convicted of 3 years in the trial court, and the appellate court modified 307 to 3025, 324.
Still you are not happy. 6 months sentence.
Only 6 months, my lord.
Only 6 months. And it is 2011. By now I don't know what might have happened. What is your age? Let us see.
After relevant time, it is 22, now it
That time 30 years.
learning court held.
See, let us see the evidence.
If your lordship come to the trial, appellate court held, it is this
Sorry?
case may be at best a offense number 324, my lord.
324.
Yes.
Where is that?
Para 11 of the appellate court judgment.
Para 11.
Page 11 of the appellate court judgment. Running to 37.
Page 11.
If he was.
Right.
Where is page 11? By.
It's like from the bottom, my lord. The act of Niranjan is held at best a case of 324 IPC, such as causing hurt by dangerous weapon.
Page 11?
Page 11.
Yes, my lord, that is page 11.
Internal page 11.
Yes, my lord.
It starts like.
Seventh line from the bottom. The act of Niranjan is held at best a case of 320.
All the accused persons have been stated during the examination 313 that where are you reading?
He was a 22 years old accused person, a father and 2 sons. Father and 1 son was acquitted. Considering the age of the citizen, to try extend the limit of the
One paragraph is supposed to have.
Court has also distinguished the action of the Niranjana from that of the other accused persons. Inasmuch Niranjana dealt lathiblow in order to kill the Prasanna. Finding of the law and courtability seems to be inconsistent with the fact, circumstance, and evidence of the case. As held by this court earlier, there is no basis on the opinion of Rule 10 that the injury on the Niranjana grievous in nature. The quarrel broke out due to family dispute, and admittedly, both parties resorted to violence. It is not understood as to how the law and court to refer to the judgment and finding on the so-called counter case in ST case or so and so. No evidence has been laid to that effect. The Rule 10 has stated that he regained his sense after 7 days of the occurrence. It is not supported by the expert evidence. Rule 5 has stated that Rule 10 was vomiting, so it was referred to SB Medical College Hospital. Rule 9, though, would have told if Rule 2 was in senseless state, he has not stated so. There is only one lateral injury on the head of the Prasanna. Intention of the accused Niranjana is not indicative from the evidence record or on the fact of circumstances of the case with the intention to kill Prasanna. He dealt a lathi blow on the head. It seems that in the process of assault, he gave a lathi blow on the head. If he has the intention to kill him, he could have given successful lathi blows and on his head or other
case of single blow.
single blow. Vital part of its body. As such, the conviction of Niranjana under section 307 IPC having no basis is illegal. The act of Niranjana is held at best a case of 324, such as causing hurt by the dangerous weapon or by means of lathi. In the circumstances in the dangerous one. Law and court will lost sight of the requirement of the Probation of Offenders Act to deal the offender thereunder. Furthermore, he had
Court below lost sight of the
the requirement of the Probation of Offenders Act to deal with the offender thereunder. Furthermore, he has taken into consideration of the prior enmity between the parties while awarding a sentence. In view of the finding of the court as above, conviction of 307 is not tenable in liable and such liable to be set aside. But on the basis of evidence on record, accused Niranjana is liable for committing offense under section 324. Thereafter, in para 9 mile, the convict told Niranjana Mahathur was aged about 30 years at the relevant time. It is not 30 years, he was 22 years, my lord. There is no allegation of proof of a previous conviction against him, though there is evidence of prior enmity between the parties. Section 324 IPC prescribes punishment of imprisonment of either discretion for a term which may extend to 3 years or with fine or with both. Having regard to the age and character and antecedent of the convict, circumstances of the commission of offense, gravity of offense, I will not inclined to extend the benefit of a pure act in his favor. Considering the degree of culpability, he is sentenced to RA for 6 months.
RA for 6 months.
It is or fine
Or fine.
Or fine. Fine, we will convert it to fines. Huh?
Yes.
So fine. Thank you. Huh? Or legally fine.
No.
Teacher. Fine, huh? Only fine. Okay. Sure. 85 Yes. 85.
I pray for 2 weeks because of
The deposition copy, it is a clear case of acquittal, my lord.
Next week.
Can I?
Next week.
Yes, ma'am.
Yes, next.
94.
94. Ninety-four.
94.
Last occasion, your lordship has directed to provide the copy of the deposition.
Nobody is appearing.
That the 94.
Nobody is appearing. What is this?
Then here is also my lord Smriti Ranjan Mahapatra and B.R. Mahanti and Mr.
Shall we appoint amicus curiae?
Yes, my lord.
Huh?
Yes, my lord. Because the last occasion your lordship was directed and I also approached to the concerned advocate personally also. You give the deposition and as per the direction of my lord, it will be finished.
The matter has been pending since 2011. It was listed earlier on 1/3/2024, 5/3/2024, and 19/3/2004, and 2/4/2024. But none appears for the petitioner. None appears for the petitioner. Petitioner. Hence, in the interest of justice, matter is urgent to services time and yes, Mr. Sahu, will you assist? Yes. Huh? Mr. T.K. Sahu is appointed as amicus curiae to assist this court. Assist the court. Let the paper book. Let race is directed to supply a paper book. ଏଠି ଅଛି ନା ପେପର ବୁକ୍ ଯୋଉଟା ଅଛି ଯାହା ଦେବ ଅଛି ପେପର ବୁକ୍ see ଯୋଉ ଏଇଟା ଯୋଉ papers whatever papers revision copy of revision along with the impugn order and Mr. Sahu is also permitted to inspect the LCR soft copy of LCR lease the matter of Friday LCR আসেনি LCR মগো call for LCR next week level next week inspect the LCR and tell and give the whatever paper book you have. Take the paper. Yes.
95.
And no adjournment will be given.
I am never taking any adjournment.
That's be sure about it. Yes.
95 on behalf of Mr. Rautre, he was there, your lordship, he was legs in other court. Let it come.
Sorry. Yes.
Last we have taken time to instruct in the status of the petition and the opposite party complaint, my lord. Grant me some more time, I can obtain instruction.
Next week.
So, one week.
Next week.
Yeah, Anipam se floor court contactor na
ଆପଣ ଦେଖନ୍ତୁ ନହେଲେ IIC concern area IIC କୁହନ୍ତୁ instruction ନହେଲେ ପଡିଥିବ କାଲି ଗଲା
they are not responding.
ଆପଣ ଯଦି contact କରିପାରୁନାହାନ୍ତି you tell the concern IIC I'll give direction verify କରି ପଚାରି କହିବ
But one week Sambodhan, then I will contact the
next week.
Yes, next week.
If you can't do,
then I will.
Then it is a matter of 2011.
Yes,
Obviously,
yes,
it's very difficult. So
Case of
I
NIA,
give a direction to the IIC to
Minute.
verify the status, whether he survive or whatever.
Yes, yes, minute.
Okay.
And NIA conviction for my 25,000 the check amount.
Conviction under?
NIA Act, 130 NIA Act.
NIA.
Yes, madam.
I'll dismiss for non-prosecution, then he'll come.
No, one time, then I will take it.
NIA, then he'll run around and come to you once he did dismiss. Shall I dismiss it?
No, can be one time, I will.
Next week. Next week we'll dismiss.
Yes, sir.
96.
See, the
And also
NIA
the-
all we can dismiss, but
the complaint,
matters, we have to appoint amicus curiae.
But the complaint also, the lawyer is not appearing, my lord. The opposite party complaint that this lawyer
You
is not
may
appearing.
not be interested also. What is the check amount?
25,000 someone.
95,000. Right, dismiss it. Forget.
Next week as well.
Neither the accused is interested nor the complainant. 25,000,
I'm-
2011 the matter is pending.
My lord. Even next Monday, I'll do instruction immediate.
Day after tomorrow.
And Monday also. Monday also.
Full dismiss it.
No, you will
Tomorrow
not
it's good for you also.
No, no,
One
you'll
pardon goes
keep it to
from
next Monday, 15th.
next Monday.
15th, yes.
Monday.
Yes, sir.
96.
LCR was called for but not received.
Conviction under
354 and 448.
354.
Yes.
Sentence.
Sentence 6 months for 354 and 15 days for 448.
50 days or
15
speak little louder. You are young boy. Don't
15
you have energy?
15
Speak louder. Yes.
15 days for 448.
448, 50,
15.
15 days.
Yes.
And 354,
6 months for 354.
6 months. What year is 40 years in 2011. How much you have undergone?
But say custody period instruction has to be obtained. Custody period instruction has to be obtained from LCR.
354 is what? Sentence or
Outrage
fine?
of modesty.
Item 97.
96.
96.
Outrage of modesty from
96 to actually.
maximum.
354 days shall not be less than 1 year. How 6 months is given? Will you show me?
Yeah, more than.
It was in the previous. That's it.
Which page?
54.6 months taken.
448 years. 6 months imprisonment. For within the sentence, 6 months.
6 months.
For the officer, 54 of 5 and fine of 1,000 from 6 months. How 6 month sentence is imposed? It says shall not be less than 1 year, but which may extend to 5 years. 6 months is given to you. Amended, subsequently amended. Or amended provision. Maybe earlier may extend to.
Lots.
For the appellate court, what does it say?
The LCR has to.
Say maintain.
Yes.
The same appellate court. Appellate court. You have the road same thing maintain, huh? Same thing. Yes.
Let me call for the LCR.
What are the allegations they see?
I'll place it, Milots, once we receive. I'll place it once we receive the LCR, Milots.
From the judgment, if you are entitled for acquittal, why unnecessary LCR? If you are not entitled for acquittal, we will see. Call for LCR. If from the judgment, if we can find something where I can record an acquittal, I will finish it up.
The only ground there I can see is enmity between the parties.
What are the allegations? What the victims, prosecutor says?
Lots.
Where is her?
At page 3 of the judgment, Milots, para 7.
Para 7.
Page 3 of the judgment.
If
Milots.
there is a
Yes, Milots.
informant testimony reveals that while he was feeding water to his son, the accused apparently read it, reached her and forcibly snatched away her son from her left, and thereafter he cut hold of her hands And possibly target inside the room. There are pretty stores over the cloud. Lay head on the ground and open a study. And then LCR is required, lot of allegation.
Also, the petitioner faced trial for 506, 448, and 255, and 354 minutes. Other offenses, the learned lower court was pleased.
LCR is called for it. It requires. Yes, next.
97.
Grateful.
90 lots.
Versus, the petitioner has been convicted on section 452 of the IPC.
52.
452 and 323 of the IPC versus.
Yes.
For 452.
Sentence to undergo?
Sentence
3
to
years.
undergo, 3 years
And
with fine 3,000.
fine 3,000.
For 452 and 323 for 323 that is right
And-
for
and
one
appellate
month.
court- Appellate court upheld that.
Appellate court upheld that. Your lordships. Allegation lordships, this petition is the drunken states with a motorcycle chain entered in the school premises. There, one teacher was there. He tried to assault. Chain was snatched by the teacher. That is the. He is the informant. The teacher is the informant. He in the statement he has stated that he has snatched away the chain. There is no assault. There is no injury. So 452 may not be made out of lordships. And
There is no injury, nothing. 323 will also will not made up.
yes, lordships. That is the case, lordships. And
Then-
at the best, 448 be attracted. Trespass, punishment for house trespass. That may be attracted.
What is the sentence there?
That is sentence of whoever commits house trespass shall be punished with imprisonment of either dismission for a term which may extend to 1 year or with fine which may extend to 1,000 rupees or with both, your lordships.
448.
448.
Charge was framed for 448.
Charge was framed, your lordships, under section the same offense, 452 and
448 was never there.
pardon, lordships.
440.
448 is
never
not there.
That allegation was not.
Allegation 452, 294,
294,
323,
323,
506 of
506
the
and 75.
yes, lordships.
You are ready then?
Yes, lordships. I will.
Then we will put it for hearing.
Yes, lordships.
When you tell me.
Next week any day, your lordships.
Huh?
Next week any day or
Next week. Next week will be. It can be heard. 22nd at 2 o'clock.
yes, lordships.
At the end of the board, we will hear it.
Yes, lordships.
Get some material so that.
Okay.
In case of acquittal, then.
Yes, lordships.
Yes.
98.
Yes. 98. What happened in this matter? Non-appears for the petitioner when the matter was called out, issue notice to the legal counsel for the petition. Again. The matter was taken up on 28th on the
Is matter
24.
is matter
The following order was filed. Fine. One. Copy supply from. Please it next week. Take. Next week.
22nd. 22nd.
Yeah.
99.
On behalf of Mr. Vasudev Pujari, I am appearing for the petitioner, my lord.
Yes.
My lord, as per order dated 2/4/2024 of this honorable court, this matter will come on 5th May 2024.
Right.
3rd May 2024.
Sorry.
As per order dated 2/4/2024 of this honorable court.
2/4/24.
Yes, my lord.
Yes, lease the matter on 3rd May.
3rd May. But this
Even
matter
it
has
al-
come today unexpectedly.
Please, it's supposed to come on 3rd May. How it is listed now? If there is a judicial order to list it on 3rd May, why it is listed? Ask him, you can't do it. According to his. There is a judicial order, judicial order. Ask who is this gentleman? Who is the name? Ask for an explanation. मजाक बनाते हैं अगर इच्छा जाए लिस्ट करी जाए judicial order फिल up कर दो sorry it will come
Obliged to me.
Item 100 and specifically go and tell the PR memo तरह पर लागू नहीं जो मैटर दरकार नहीं फिर वो लोग yes
Item 100.
100
Item 100.
option seeks accommodation into non-availability of origin counsel. The matter was listed on 14/11/2023. Then counsel for the petitioner a short time on the ground that the argument also was not available, and the matter again was listed on 2/4/2024. On that day, none appeared for the petitioner. None appeared for the petitioner. In the interest of justice, by last chance, the matter is listed on Friday. Friday we can make it position. Yes. Now all the matter will call for. Fine.
Next week ଜାଣିପାରିବ list ଆସିବ
List ଆସିବ ନା ଏଇଟା list ଆସିବ.
ଏଟା list ଆସିବ ଏଟା weekly list ଆଜ୍ଞା.
No, I am giving a date. Yes, I am giving a date. Nothing doing. A matter specifically, I will shift over and exhaust the list and go today.
ଆମକୁ ବସେଇ ଦଉଛନ୍ତି ଏଟା 5ଟା
Do your 2011 matter. If you don't cooperate, then it will be like this only. I am also sitting, you know.
ଆପଣ ବସିବା ମୋ ବସିବା ଭିତରେ difference ଅଛି.
You can sit and go and relax. Thereafter also you have to work. That is also there. You must think that.
More matter.
Let us adjust. Let us adjust the board because see these matters are pending from years. Let us see if some matter can be disposed of, already undergone, recusal and everything. We will finish that. That we will try. Not that prejudice to anyone. Let us.
More matter ଟା ପଡୁ ମୁଁ କହିବି.
Let us work together so that we can burden.
Since notice, since notice issued to
She was objecting to that. I tell you, then sit, I will explain. Don't tell me all these things. No, what I law, this is the practice everywhere. I have also, madam, I have also put in 32 years. I have got thousands of notice. It is not a notice. It is not a notice to come and explain. It is a notice to only intimate you. Your matter is listed. Please come. Don't make exception to the small things. And if you want to create an issue for everything, you can create issue. What is this?
Small thing.
It is an explanation sought from you. It is a notice to you that your matter is listed. Please come.
Notice for issue notice to the Miss Dipali Mahapatra with register postal.
That's not the issue, madam. It is only notice to the council. If the council is see many a time what happens, matters are listed, council doesn't know. Matter is 2011. So therefore, please give the notice.
issue ଆପଣ ଓକିଲର ଭଲ କରିବାକୁ ଚାହୁଁଛନ୍ତି ମୁଁ ସେଟା କହୁନି କିନ୍ତୁ ସେଇ ଇସ୍ୟୁରେ ଆପଣ ଷ୍ଟେଟ୍ କାଉନସିଲ ଯୋଉ ପ୍ରେଜେଣ୍ଟ ଅଛନ୍ତି ତାଙ୍କୁ କହିବା କଥା ତାଙ୍କୁ ଇନଫର୍ମ କରିଦବ।
ସିଏ ନ କଲେ ଆମେ ପଡିଥିବ
ନା କେତେବେଳେ ଇନଫର୍ମ କରୁଛୁ ସେ ଆସିନାହାନ୍ତି ଏଚକେ ପାଣିରେ ଇନଫର୍ମ କଲେ ସେ ଆସିଲେନି ୟୁ ଲର୍ଡସିପ ଆପଏଣ୍ଟେଡ ଆମିକସ୍ କ୍ୟୁରି
what to do you tell me
that is the right
if the bar will not cooperate then I'll stop it then I'll go what is the problem it makes no difference to me
ତେବେ ଆପଣ ଇଏଟା ବୁଝୁନାହାନ୍ତି ଗୋଟେ ଜୁଡିସିଆଲ ଅର୍ଡର ପାସ୍ ହବ ଟୁ ଇସ୍ୟୁ ନୋଟିସ୍
yes it is allowed it is allowed shall I get the notices to you
ଆପଣ ଓଡିଶା ହାଇକୋର୍ଟ 1948 ରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଦେଖନ୍ତୁ ଗୋଟେ ଥିବ
this is not try to appreciate this is not a notice for asking for explanation it is only put to you to notice please your matter is listed come it is helpful to the bar
ଆପଣ ଜୁଡିସିଆଲ ଅର୍ଡର ପାସ୍
It is not for an
I can only pass judicial order
today morning also my lord also
କେତେ ଗୁଡା କାମ ନିଜ ହେଇଯାଏ
don't take it
my lord today morning I also my lord
cooperate and let us finish up
ମୁଁ ଆପଣଙ୍କୁ
get it
ଗୋଟେ ରିକ୍ୱେଷ୍ଟ କରୁଛି ଯେ ଆପଣ ସେମିତି ଜୁଡିସିଆଲ ଅର୍ଡରଟା ପାସ୍ କରନ୍ତୁ।
I'll see judicial order to be passed by the judge only. Let him decide. Chalo, I'll take care of your this thing also. I'll take as a suggestion by you. I'll take it in that spirit. Please sit down. Let us finish it up. And it is a good thing that you have brought it because the bar is taking. Otherwise, then I will not. I'll stop it. But it is a loss to the bar. I must tell you, loss to the bar.
no in spite of that some persons are also appearing before lordship
See, but notice kalabare there see the appearance today. The other day none appeared.
ହୁଏ ଯେତେବେଳେ ଆପିୟର କରିବେ
ଚାଲନ୍ତୁ ଆପଣ ତ ଆସିଲି ନୋଟିସ୍ ନୋଟିସ୍ ନଥିଲା ଆପଣ ବି ଆଇନାହାନ୍ତି
ଏଇଟା ମୁଁ କ୍ୟାରେକ୍ଟର ନୁହେଁ ସେଦିନ ଆଜ୍ଞା 4:15 ଯାଏଁ ମୁଁ ବସିଲି ଦେଖିଲି ଯେ କେସଟା ପଡିବନି ବୋଲି ସେଇଠି ମୁଁ ଏବେ ପଡିବି
अभी 7ଟା ଯାଏ ବସିବାକୁ ପଡିବ ବସନ୍ତୁ ଟାଇମ୍ ୱେଷ୍ଟ କଲେ ବସନ୍ତୁ ହଁ
101 made majorities. This is also a case of acute.
the rollover na gala do you know 9,000 matters are pending
ଆଜ୍ଞା 38 ବର୍ଷ ଏଠି ରହିଲେଣି କୋଉ କଥା କିଛି ଜାଣିନି
then when will you finish it up
ସେଟା ହଉଛି ଦେଶର ପ୍ରୋବ୍ଲେମ
ନା ନା ଦେଶର ପ୍ରୋବ୍ଲେମ ହେଲେ ଆମେ ମିଶି କାମ କଲେ ଦେଶର ପ୍ରୋବ୍ଲେମ ଟିକେ କମ ହବ ନା ମିଶି କାମ କରିବା ତାହେଲେ ଯାଇକି କମ ହବ
ଆପଣ ଏଠି କ୍ରିମିନାଲ ଲିଗଲ ସାରିଦେବେ ସେପଟେ ସେକେଣ୍ଡ ଅପିଲ ପେଣ୍ଡିଂ ହେଇଯିବ
କିଛି ହବନି ଆପଣ କୋଅପରେଟ ୱିଲ୍ ଡୁ ଡୋଣ୍ଟ वरी
ଆପଣଙ୍କ ସେକେଣ୍ଡ ଅପିଲ କ୍ରିମିନାଲ ଲିଗଲ ସିଆରଏମସି ସବୁ କରିପାରିବେ
ନାଇଁ ନାଇଁ ସବୁ ତ କରିପାରିବେନି ଯେତିକି ଯାହା ହେଇପାରିବ କରିବା ठीक है anyway 101 nobody appears
Your lordship, I am here.
अच्छा ଆପଣ हां कौन
Your lordship, petitioner will be convicted under section 279, 337, 338, 304.
you are ready to
Yes, lordship. It's a case of acute lordship.
see how the matter thila
That was posted to 22, your lordships.
22 दिरा करि परिबे
Yes, lordship.
दिरा को रख दियो 22 get ready we will finish
Yes, lordship.
102 102
Wait,
yes
wait, please, Your Lordship. I am on behalf of SC Mahapatra.
yes
I have no power in this matter. I have no power in this matter. But sir, directed.
anyway tell me what is the case
My lord, here, my lord, the petitioner convicted and undergo SI for 1 year by the learned court below. Thereafter, the petitioner preferred an appeal. In the appeal, my lord, the sentence modified and the court below directed the appellant is sentenced to pay fine of rupees 1,000 in default the SI for 2 months, my lords. Here, my lord, 353 is not at all applicable, your lordship. Because, my lord,
then substantive sentence is only fine
fine, your lordship. Fine imposed by the appellate court, 1,000 rupees at the year of 2011.
you say it's the case of acquittal
Yes, my lord. Because, my lord, there is a clear discrepancies. Like, my lord, the occurrence placed at SDJM Sadar Court, my lord. Some of the witnesses said it is a JMFC
will
court.
you insist for acquittal or will you be happy with the sentence reduced
I want.
acquittal if you want an acquittal then it has to be heard
Yes, my
I'll
lord.
hear you
Yes, my lord.
you tell me then, if you want to insist for acquittal
My lord.
okay give tell me Friday
Friday, your lordship.
Friday keep it to Friday get ready
I will prepare a short note, 2
Short
page
note
note. Yes, ma'am.
so that yes
Grateful, ma'am.
102
103
3. Okay, 3. Yes.
My lord, in item 103,
Yes,
I am
madam.
the VC, my lord. The petitioner was convicted under section 452, 352, and 376.
Are you ready?
I am partly ready. I need some deposition, my lord. That conviction was also confirmed.
Madam, LCR is there already.
Yes, LCR is
And you
there.
please inspect. I am permitting you.
Yes.
The soft copy of LCR is there on record. Let counsel for the petitioner seeks to inspect the record. The inspection is permitted. This is matter for one hearing next week. 22nd. Just the soft copy is there. You just I have permitted you go and see the soft copy, note down and
Yes, yes.
Okay.
Yes.
22nd.
22nd.
Yes. Next.
104.
Yes, my lord. My lord, I am appearing on behalf of my knowledge senior Mr. S.K. Nanda. My lord, this is a matter of 2011, my lord. In the year 2011, the petitioner was 70 years old.
That time.
Yes, my lord. But now we don't have any instruction about the well-being of the petitioner, my lord. We have sent the letter, but yes, yes, sir.
Rahul,
My lord.
I you want to cover
My lord. 105? 104.
What was you said the revision was filed on the revision was filed on 12/12/2011.
My lord, may I request one thing by your lordship, my lord. One copy may be kindly supplied to me.
12/12/2011. At that point in time, the petitioner was 17 years old. The consequent petitioner submits that he from the petition, and he could not contact the petitioner. IIC, which IIC? This is village.
No,
Dasapala, Kutru, address Kundu.
village Guruha, the village Guruha, Daspala, district Noyagad.
IIC Dasapala here is directed to ascertain the status of the petitioner in court. Adjourned. Matter next week.
My lord, a free copy may be, my lord.
A free copy. Copy with a photocopy evidence. ठीक है जी सब दिया फटाफट दिया नेक्स्ट वीक 22 23 26 शेड्यूल लगो 23 ठीक है
Village.
105.
May I please, Your Honor?
Yes, sir.
In this case, my lords, petitioners are found guilty, my lords, 323 and 34 IPC, my lords.
Sorry?
Found guilty, my lords, under section, my lords, 323 and 34 IPC, my lords. Sentencing under 1 month each, my lords. The petitioners are government employees, my lords, for playing next week.
Okay, next week. You are ready?
My lords.
Next week. Yes. 6.
106. 106 already touched. 106 already touched.
107. 107.
Yeah, only 332 allegation, conviction 3 years, 3 months, and pay fine of rupees 100 each.
3 months.
3 months.
Okay.
And fine 1,000 each. There are 2 appellants. 2 petitioners convicted by the learned SDJM. Thereafter, appeal filed by the appellant petitioners. The conviction and the sentence confirmed by the appellate court. Therefore, before your lordship, the
Yes. What are the sentence? The offense under section
332.
332
and 34 IPC.
Where are item number?
107.
What is the maximum sentence given? 332.
Maximum 3 years, your lordship, tribal by magistrate.
Extendable to 3 years.
Yes.
332.
32.
34. There are two appellant, two petitioners before your lordship,
Or with fine,
or with.
or with both. So we can reduce the sentence. Fine.
Yes, sir.
Fine.
Yes.
Okay.
Okay.
Happy with whatever fine. Fine will be the clear judgment is over. Conviction maintained, sentence reduced down to fine.
Fine.
Okay. Okay. Very good. Take
108.
108, yes.
May I please?
Hmm.
108, your lordship's last occasion stated that if petitioner will not come, then I will. This is NI Act case, my lord. And petitioner is not coming. For that reason, your lordship's last occasion stated.
You are for respondent.
I am for the respondent, opposite party.
This revision is arising out of the judgment dated.
Judgment dated SDGM 11/9/2012 and.
No, this is the case arising out of a complaint under complaint under section 138 NIL. The SDGM na प्रथम case conviction करथिला.
This is my lord SDGM Baleshwar.
SDGM Baleshwar by the order dated.
Judgment dated my lord 22/3/2010. 22/3/2010 man. 22/3.
Record a conviction against the petitioner and and impose the fine of rupees. Conviction
5,000 rupees fine and 1,25,000 as 1,35,000 compensation money.
Sentence the petitioner for offence under section 148 NIX and pass the following sentences. It is into page number 9. Page 30, running page 30, SDGM last paragraph. Okay. So sir, the petitioner agreed by the aforementioned conviction and sentence. They filed the appeal before the court of additional sessions judge, special judge Vigilance Baleshwar. White order dated 11/9/2012. This was offense. Conviction and sentence passed against the petitioner was upheld by the appellate court. Appellate court. Appellate court. So, sir, against the state judgment and order judgment of conviction and sentence dated 11/9/2012. The present revision is filed. The revision is pending. The present revision is pending since 2012. On repeated call, none appears for the petition. Therefore, the present revision petition is dismissed for non-appearance.
109.
Lordship, maybe permission. Lordship may dispose on merit matter, non-prosecution.
Non-prosecution revision.
Revision ta non-prosecution. Lordship.
That conviction is for the non-prosecution. It's a complaint case.
Complaint case, na?
Conviction.
138
NIA. That is the reason. That's the reason. Yes. Yes.
109.
Se puri restoration ragi aisa judgment ହେଇଗଲେ better ହବ. Se puni restoration puni
न सुनिकरी कन्विक्शन अपील करदा ठीक नहीं ना न सुनिकरी कन्विक्शन ठीक नहीं मेरिट रे कोरियर ठीक नहीं न सुनी
ठीक है
dismiss in default they may not be interested
they may not be interested because parties are not
if they move application will see
but in criminal revisions matter there are certain decisions on the appeals court matter they cannot be disposed of as non-person dismissed for default or non-prosecution matter. The court has to read out the entire matter evidence and assign the good reason and pass the order. One thing. Second thing,
see, if it is arising out of a complaint case, particularly quasi
criminal proceeding.
Therefore, so therefore it is can be dismissed in default and nobody will come forward. He is not interested. Let it be like that. Don't go. Time amicus curiae kuriya padibo jodi conviction is. Seta kari pariboni. Seta problem. Yes.
109.
No, everybody, madam, everybody is learning in that. Everybody is learning, don't worry. Yes.
109 will I have tried my best to contact the petitioner minor, but so far as my instruction is concerned, minor, the learned counsel from the trial court said that the petitioner is expired, minor.
See, 2012,
My lord.
you were 62.
My lord.
I don't.
As per my instruction received from the learned counsel from the court below, my lord, the petitioner has expired, my lord, but I have no such document, my lord. Your lordships may direct the learned counsel.
IIC
My lord.
report.
My lord.
IIC uchi chitro TS Firingia.
My lord.
TS Firingia. Report kori next week.
My lord.
110.
I plead your lordship. Conviction for 2 years for offense number 326, your lordship. Last occasion, the lordship specifically directed me.
You are ready. You are ready. Put it on Friday. Friday.
Last occasion, the lordship specifically directed me how much you remain in the custody. That I have filed an affidavit on the.
How much?
1 month, your lordship.
Offense is?
Of 326. And
Grievous.
yes, your lordship. 326, 324 and 148.
Can we reduce down?
326 at 2 years.
Reduce, correct, correlate.
I will satisfy your lordship because the ingredients of 326 doesn't attract in this case, your lordship.
Then I'll hear it. Hear it out. Friday.
And moreover, your lordship, in the meantime, all the petitioners, they were summoned by the court below in a CMC proceeding, and all of them deposited the fine amount before the court below, your lordship. That I filed an affidavit on the last occasion, your lordship special indictment to produce it on the next
We'll
day.
see. This Friday. Friday. Right. Yes.
111.
Yes. In this case also the same thing problem. For the make it good. Take it. And non appears despite the matter was listed on 22/4/2024 and following order was passed. Following order was passed. None appears on behalf of the petitioner and the case courier.
The lawsuit can appoint any junior counsel for them.
Who can do it?
legal aid रा use करो
ତାପରେ ତାଙ୍କୁ ଖୁସିଥିବି ମୁଁ ସେଇଟା ପ୍ରୋବ୍ଲେମ ଆଇ नो ମତେ ନାହିଁ ମୋ ପାଖେ କପି ନାହିଁ ମୋ ପାଖେ ଇଏ ନାହିଁ ମୋ ପାଖେ କିଏ ନାହିଁ କୋର୍ଟରେ ଥିଲେ ଏଟଲିଷ୍ଟ ଆଇ କ୍ୟାନ୍ ଟେଲ୍ कि भाई you do this that
usual practice है bro court direction either way has that be happened
some young lawyer who can get an opportunity also ସେଇଟା ରିଲିଜ କଲେ କି effective assistance भी नहीं चलो देखिए और कर दो प्रोसीजर कर दो ठीक है काउंट करियो ठीक है नेक्स्ट
112.
yes
In first matter, my lord, I am for the opposite party, my lord. In the connected matter, I am for the petitioner. My lord, is the
what are the offenses? You are the accused.
I am that.
What is the check amount?
8,50,000.
Huh?
8,50,000.
खत्म करना चाहिए.
My lord, the appellate court my lord, the appellate court what he has did, my lord, the trial court confirmed awarded the compensation at 14 lakhs and 2 years SI, my lord. In appellate court, my lord, the appellate court reduced the amount to 3 lakhs, my lord. That is much.
Check amount कितने?
Check amount 8,50,000.
The appellate order has to go.
And my lord, and relying on the judgment, my lord.
If the check amount is 8 lakhs, either you convict or you acquit. How can you reduce to 3 lakhs?
Check was not issued.
Then acquittal.
Legally,
if check is not issued, acquit it. No problem.
Yes.
But if the check is 8 lakhs, how can you reduce?
I issued blank check.
blank check, my lord.
That is.
Whatever, there is a check, there is a check.
Yes.
Blank check, if you have issued, it is manipulated, whatever, you are entitled for acquittal, no problem.
Miller.
You satisfy me, I will acquit.
Yes.
But how the appellate court reduce it to 3 lakhs?
That order I have challenged. I have also.
He also challenged that.
He challenged, no, he challenged. I challenged both the orders, appellate court and the trial.
You should be happy with the appellate order.
No, my lord.
8 lakhs.
No legally enforceable debt, my lord. And a notice was not served.
There is no question of settlement?
No, my lord.
No.
Think over.
No.
My lord, but if we submit, my lord, your lordship fix up a date. In all the, in both the cases, we have written note of argument has already been filed. And matters earlier was heard by this.
It was extensively argued and a
Yes.
note of argument also filed.
But I only friend, lordship may put up.
What's 138 meter, what extensive argument 2 courts have held?
Yes,
against
yes,
you?
my lord, yes.
What
that is
extensive?
the-
On 3 points, my lord.
Put it on 23rd, I'll finish it up.
Obligation.
I don't think extensive hearing is required.
No, my lord. So,
In this case required, my lord. Even demand notice
See,
is not
regional
issued.
court jurisdiction
My
is
lord,
very.
my lord, demand notice is not issued and company is not made a party.
only this in revision case, in revision one, lordship has to have the point of law only.
Yes.
And they are just,
Yes.
Let us,
yes.
Obliged.
23, huh?
My lord.
Both the matters means 12 there.
It's connected matter.
Obliged.
113.
May I please? It's convicted under section 325. Not sentenced to undergo SI for 2 years and fine of 500.
Hmm.
The conviction is based on the evidence of PW2, who is the injured, PW1 is the informant, and PW9 the doctor. That is a concurrent finding. Lords, I am not on merit. Your lordship may extend the benefit of section 4 only. Because one
Section
paragraph,
4.
of section 4 of the probation of offenders
Probation.
act.
Had you had moved an application there?
Lords, that was argued, that plea had been raised, but it was not taken into consideration.
It was rejected.
My page 19, trial court judgment, your lordship.
19, huh?
Because there is no previous conviction
That's right.
and is the sole breadwinner of the family.
19? Okay.
Internal page 19 of the
Yes.
trial court judgment.
About the sentence, question of.
Hard on the question of sentence.
Line 4, line 5th.
Hmm?
Line 5th.
Yes.
You put it in the
You
complaint.
also submit that your
Yes.
application may be
Hmm?
dealt with under
You-
probation of offense section.
अरे मुंह पढ़ो।
Because there is no.
Other
No-
accused person may
no
also be
prior
dealt under
conviction.
probation of offenders act because there is no proved prior conviction against any of the accused persons. He submits that Padma and Hari, well, also there were 3 accused persons.
Middle
Hari-
East.
Yes, middle-aged person and the sole breadwinner of their family for which some leniency may be shown to the. But that was never considered. So also the appellate court judgment, my lords, the one line has been said about the POF. Lords,
You do one thing, you move an application here. Exhaustive application.
not
Giving the reason, I will
necessarily.
allow that.
Lords, your lords, I am relying on the judgment of this honorable court.
Sir, that's what today, I'm simply adjourning it, move a separate application under section 4.
Well,
Provision, relying upon all this thing, I'll reduce that and allow that application.
on my oral prayer also can be done.
You do it because today I can't do it because that is, we don't have time. 4:30, you do it. Move an exhaustive application, what is wrong in it? That will be easier for me to write it down also.
Like,
And shall I put it on Friday?
next Monday.
Okay, Monday. 22nd?
Yes.
Move an application, exhaustive application, give reasons as per the requirement of law and reproduce the relevant paragraph
Mal,
of the
mal,
judgment. I'll reproduce that and allow.
Your lords may record that so that my lords.
I'm there, don't worry. I remember. No, then counsel for the petitioner submits that he is not questioning the conviction order. However, he is agreed by the fact that his application under section 4 before the trial court for extending the benefit.
Not application, only plea
Right.
was raised.
The plea of the petitioner for extending the benefit of Provision of Offenders Act has been turned down. And he wants to move an exhaustive application before this court and pray for time. This is the matter on 22nd. So that it will be easier to recall
Mal.
here.
114.
May I please, my lords?
Hmm.
Petition convicted under section 354 and 506 to 2 ବର୍ଷ।
କମିଗଲା
ସେ ହେଇନା ତା ଦେହରେ ଆଇଟନେସ୍ କେହି ନାହାନ୍ତି ବେସିଂ ଷ୍ଟେଟମେଣ୍ଟ ଦ ଭିକ୍ଟିମ୍
You want an acquittal?
ଆକ୍ୟୁଟାଲ ଆପଣ ସେମିତି ମୁଁ ଆକ୍ୟୁଟାଲ ଚାହୁଁନି ଆପଣ
Sentence କଣ?
এটা victim minor ଅଛି।
minor of
You have rejected.
minor
PW4 is the victim. PW2, 3 are parents.
But it needs to be heard then. These are terror, na?
ଆଜ୍ଞା
I am fixing it next week.
ଆଜ୍ଞା
Next week. What best could be done? You tell me, suggest.
ସେଇଟା ତ ଗୋଟେ ସ୍ୱାମୀ ମାଇନର କୁ ବ୍ୟକ୍ତିଙ୍କ ମାନେ ଷ୍ଟେଟମେଣ୍ଟ ର ଭିକ୍ଟିମ କୁ କନଭିକ୍ସନ ହେଇଛି ଆଇଟନେସ୍ କେହି ନାହାନ୍ତି ମଦର ତା ପାଖରେ ଥିଲା ମଦରକୁ ସେ ଝିଅ ମଧ୍ୟ କହିନାହିଁ ମଦରକୁ ଯାଇ ଘରେ ଯାଇକି ଝିଅ କହୁଛି ମା ଝିଅ ଦି ଜଣ ଆଇଥିଲେ
Mother was examined.
ମଦର ଏକ୍ସାମିନ ଫାଦର
Mother support.
ମଦର କହୁଛି ମଦରକୁ କହିଲା ନାହିଁ ଝିଅ ଯେ ମତେ ସାର୍ ଏଇ କାମ କରିଛ ମାନେ ମିସବିହେଭ କରିଛନ୍ତି ବୋଲି
He's a teacher.
So teacher.
ଟିଚର ସେ ଖାଲି ଟିଚର ଗୁରୁ ନେଇକି 2 ବର୍ଷ କନଭିକ୍ସନ କରିଦେଲେ ଯେହେତୁ ଗୁରୁ ଆଉ ଶିଷ୍ୟା
Conviction.
ଇଏ ଡ୍ୟାନ୍ସ ଟିଚର
Illegality.
354 ଏଲିଗେସନ ପୁଣି କିଛି ବିଶେଷ ନାହିଁ
କଣ କହୁଛନ୍ତି?
Conviction ରେ କିଛି illegal ନାହିଁ।
କିଛି
Rightly convicted.
Sentence is reduced.
ଯଦି sentence ରେ କିଛି ଦିନ period ରେ ତାଙ୍କର
You might have.
ଏଇ ପିରିୟଡ ଟା କେତେ ଦିନ ମୁଁ ଜାଣିନି
You might have lost the job also.
ଚାକିରି ପ୍ରାଇଭେଟ ସ୍କୁଲ ଟା
ଏଟା drawing teacher.
ପ୍ରାଇଭେଟ ସ୍କୁଲ ଯୋଉ ଆମର ଶିଶୁ ମନ୍ଦିର ବିଦ୍ୟାପୀଠରେ ନାହିଁ ଡ୍ୟାନ୍ସ ଟିଚର ହଉଥିଲା ସେ କହିଲା ମତେ ମିସବିହେଭ କଲା ଦେଶୀ ତ ବେଶ ମା କୁ କହିଲାନି ମା ଝିଅ 2 ଜଣ ଆସିଥିଲେ ଝିଅ ମା କୁ କହିଲାନି
ଦେଖନ୍ତୁ ସେଣ୍ଟେନ୍ସ ଉପରେ କିଛି କରିବେ ଦେଖନ୍ତୁ
ଆଜ୍ଞା
ନେକ୍ସଟ ୱିକ୍
Custody period ଟା କେତେ ଅଛି?
already undergone वगैरह କିଛି କରିବେ ବୋଲି ଦେଖିବା କଣ କରିବା
ମାନେ ସମନ୍ସ ପାଇକି ଆସିଲି ମୁଁ କହିବାକୁ
see that issue is gone now you tell me on the merit what can be done
ଦୟାକରି ସେମିତି
आप कौन तू next କଣ କରିବା
Conviction 323. It's 320 for your lordship will carry
323
324 my lord.
sentence
34.
sentence
1 year my lord. Your lordship will carry turn to page
reduce down
No, 64 टा क्यों देखो
164
खाली 64 trial court judgment. Internal page 13.
your internal page 13
हाँ trial court
not be read also then paper
ଆମକୁ ଯୋଉ
କାହିଁକି ସେଟା କରୁଛନ୍ତି ଆଜ୍ଞା ମୁଁ ସେଟା ବୁଝିପାରୁନି
ନାଇଁ that is the best thing but ଆଇରେ ସ୍କାନିଂ ଆଇରେ ବି କିଛି ନାହିଁ କିଛି ପଡିବ କଣ କରିବ
ଆଉ
ଆଜ୍ଞା ଆମ ପାଖରେ ବି ଗୋଟେ ୱାର୍ଡ ଦେଖାନ୍ତୁ
କିଛି ଦେଖାନ୍ତୁ
ସବୁ ଦିଶୁଛି ଆଜ୍ଞା
ଗୋଟେ ଲେଟର ଦେଖାନ୍ତୁ
ଆପଣ ସାର୍ଟିଫିକେଟ କପି ଦିଆ ହେଇଥିବ ଆଜ୍ଞା ସାର୍ଟିଫିକେଟ ନହେଲେ ରିଜେକ୍ଟ କରିଥିବ
you could have you might have managed without certificate copy
ବୁଝୁଛନ୍ତି ମତେ
କାଇଁ କିଛି ନାହିଁ ଦେଖ
ସାର୍ଟିଫିକେଟ କପି 100% ଦିଆ ହେଇଥିବ ନହେଲେ ରିଜେକ୍ଟ କରିଥିବ
ନାହିଁ ପୁରା ଦେଖୁଛି ଏଇଟା ଅଛି ଯେ ଏଇଟା ବି ଦୁସୁନି
ଆରେ ଆପଣ ମୋ
anyway ପଢନ୍ତୁ
ମୋ ବ୍ରିଫଟା ଦେଖ
ପଢନ୍ତୁ ଦେଖିବା ଏଇଟା
ମାନେ ଗ୍ରାଉଣ୍ଡସ୍
one କୋଉ ଗ୍ରାଉଣ୍ଡ ରେ
these are 3 grounds my lord. The prosecution has not examined any other witness though there are 40 to 50 people of this sort during the occurrence as disclosed from the evidence of the witnesses. The oral evidence regarding the assault is not in conformity with the medical evidence as the doctor found no injury on the throat of the victim or on the legs of the victim alleged to have been caused by the acute sonatana and the acute bruising. The present case is a counter case to the case filed by the accused and
these are findings.
These are the points which I have argued.
Okay.
For the trial.
What are the findings?
And the finding your lordship comes. Your lordship paragraph 10. So far non-examination any other witness has pointed out the defense is concerned. The law is versatile in this regard. It is settled position of law that the prosecution has to decide on which witness it would place its reliance. So non-examination of any other witness out of the gathering of the public cannot be said a drawback in the case of prosecution. Lord and Counsel the accused however confident that the witnesses 2, 3 and 4 are all home guards and the victim also being a home guard. They have all colluded, created a false case, but such a contention cannot be accepted as there is no explanation as to how the informant sustained injury. Well, how the informant sustained injury, it is not my business to explain. Medical evidence does not support the prosecution case. That is at paragraph.
And what
paragraph 12,
appellate court says what?
Appellate court has not discussed anything, only confirmed. Paragraph 12 will also change. Medical evidence does not corroborate. paragraph 12.
Then
And counter cases.
evidence of PW 2 to 4 having consistency.
They are the all home guards.
Conformity to bureau.
They are all home guards. The genesis of the case is that the informant put a cabin in front of my house. I have made a complaint before the Proceedings. On the orders of the Proceedings, that cabin was removed. On the date of occurrence, it is alleged that he was removing the cabin and my wife gone there. Where my lord, there are some hot exchange of word and they have outraged the modesty of my wife and also other offences, man. That is the genesis of the case, man. And so many persons, 40 to 50% were present. None of the independent users of that village have been examined. All are home guards. And the informant is also.
PW 2 to 4, all are home guards.
All are home guards.
And the corroboration of the evidence is drawn from 2 to 4 statement and conviction.
And medical evidence is also not supported the prosecution case, paragraph 12.
307 acquitted, it is converted to 324 and 34.
Medical evidence भी support को मिला।
किसी कागज नहीं देखिए किसी कागज पेपर्स नहीं
आपण इटीवी नहीं इटीवी किसी दूसरी नहीं देखो तो अपन किसी दूसरी सर्टिफिकेट कॉपी
हाँ मुझे तो से सर्टिफिकेट कॉपी नहीं जेरॉक्स करছি
नहीं नहीं
मत तो गोटे देखना
ये ट्रायल कोर्ट किसी दूसरी
ट्रायल कोर्ट जजमेंट आगे सर्टिफिकेट कॉपी ଥିବ ନା ଏଟା ମୋ ଏତେ ସୁନ୍ଦର ଆସିଛି
ଦେଖୁନ
and if the only my submission is if the judiciary here
ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ ଆପଣଙ୍କର ଫାଇଲ ଟା ଦିଅନ୍ତୁ ମହାରାଜଙ୍କୁ I have heard you and he'll just assist him with finish ଟା
ନାଇଁ ଆପଣଙ୍କୁ ବି କିଛି ଦିଶୁ
କିଛି ଦିଶୁନି
ମାନେ only
ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟ ମୁଁ ଦେଖଉଥିଲି ଆପଣଙ୍କୁ
ଆଜ୍ଞା ଆଜ୍ଞା ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟ ଟା ଦେଖୁନାହାନ୍ତି ଆପଣଙ୍କର ଭଲ ଅଛି
ହଁ କିଛି ନାହିଁ
ମୋଟା ବହୁତ ଭଲ ଅଛି
ଆପଣଙ୍କଟା ଭଲ ଅଛି
ଦେଖୁନାହାନ୍ତି
you wanted the court shouldn't read and you read and decide you give your copy
ସେଟା କଣ ହବ
ଆଜ୍ଞା ମୁଁ ଦିନ
ଆପଣଙ୍କର
ସିଏ ଦେଲା ପଢିଲା ପରେ ମୋତେ ଆସିଟ୍ କରି from there I dictate the order what to do
ନା 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 ମୁଁ ଆପଣଙ୍କୁ ଗୋଟେ କପିଟା ଦେଇଦେବି ନା
ଫଟୋ କପି କଲେ କିଛି ବାହାରିବନି ବାହାରିବ କରିକି ଦିଅନ୍ତୁ ତାହେଲେ ମହାରାଜଙ୍କୁ ଦିଅନ୍ତୁ ମତେ ଦିଅନ୍ତୁ
ନା ମହାରାଜଙ୍କୁ ବ୍ରିଫଟା ଦେଇ ଦଉଛି ସେଟା ମୁଁ ଯାହା ରଖିବା କଥା
ଫଟୋ କପି କରି ଦେଇଦେବେ ଜଜମେଣ୍ଟ ରିଜର୍ଭ ଠିକ the only you address see if you want to sustain 324 the corroboration need to be drawn from the medical evidence the doctor doesn't support the case and 2 witnesses 2 to 4 witnesses their testimony is being corroborated with PW1 who is the injured and there it has taken place the incident takes place in the open this thing none of the independent witnesses were examined these 2 people are the home guards so it creates a clear doubt regarding the conviction so that is the whole gamut what he is arguing
and genesis
and the strongest point is the doctor is not supporting it.
Doctor evidence is there for a moment I want to say.
That's why you just see.
But here the request copy is not there. Doctor evidence is required. Whether he has supported or not. Only that you will see. If that is there, then
there is nothing.
Absolutely, my
that's what it is. We should believe that.
No.
And he read it out.
No.
That was revision. Finding of the trial court ମୁଁ ଆପଣଙ୍କୁ ଦେଖଉଛି
ठीक है we understand ठीक है we'll do it ତାପରେ ଦେଖିଦେବେ
କିଛି ନା ଖାଲି ଯାହା ଦେଇଛନ୍ତି ମ୍ୟାଡାମ ଦେଇଛନ୍ତି ସେଟାକୁ ଦେଖିବେ 116
ତାର ଫାଇନିଂ ଲେଖା ଅଛି
ହଁ
ଫାଇନିଂ ଲେଖା ଅଛି
କେତେ ପେଜ ଟିକେ ଏଇଠି କହିଦଉନା ମୁଁ କହିଦଉଛି ଦେଖି
ନାଇଁ ଆପଣ ପଢନ୍ତୁ ନା ଆରାମରେ ପଢନ୍ତୁ
paragraph 12 trial court judgment
ଏଇ ସାଧୁବା କାଇଁ ଆଉ ରଖିବା କାଇଁ paragraph 12 ଗୋଟେ ମିନିଟ ଲାଗିବ
ଆପଣ ଟିକେ ପଢନ୍ତୁ ହଁ paragraph 12 there is a finding that the doctor has not supported the prosecution
X-ray report
X-ray report 9 Yes, sir.
তাহলে আর কোন রইলা
Yes, yes, yes.
একুটাল করে খতম করো
Technical দেখে দাও কিন্তু সে কোন
তাহলে,
রাইট
ଆପଣ এই ফাইলটা দিও
আগে
ମୋ document ଟା বার করে দিদি।
ডকুমেন্ট ବି ଥିଲେ କିଛି ଅସୁବିଧା ନାହିଁ you have the fee which you have received there is must be something you remove that so it should be
ମୁଁ ଆଜ୍ଞା ଜମା କରୁଛି।
privilege communication between you and your client I don't want to see that
ନାଇଁ ନାଇଁ ଆଜ୍ଞା ମୁଁ ଖାଲି ଏଇଟା document ଟା ବାର କରି ଦେଇଦେବି ଆଉ କିଛି ନାହିଁ।
ସେ ଉପର କାର୍ଡଟା ବାହାର ଅଛି
ये ऊपर पेपर टा
ନେମ୍ ପ୍ଲେଟଟା ବାହାର
ନହେଲେ ପୁରା ଏଣ୍ଟାର ଭିତରେ ଦେଇଦେବି।
बस कश्मीर बंद जजमेंट रिजल्ट yes
116
yes
ଆଜ୍ଞା ମୋ କଥାଟା ଟିକେ ମନେ ରଖିବେ।
ମନ ରଖିଲି ବୋଲି ତ ଏକୁଟାଲ କରାହଉଛି ନହେଲେ ଆପଣ କନଭିକ୍ସନ କରିଥାନ୍ତୁ
ଚ୍ୟାଲେଞ୍ଜ କରିବାର ନାହିଁ।
ଚାଲନ୍ତୁ we'll take care yes next
Lordship, item number 116, praying for an adjournment.
why urgent you argue
No, senior counsel will conduct.
no you have to argue
Lordship, it's a
you argue this is an opportunity I am appointing youngster as amicus curiae
Previously he was
subject to condition that you will argue I will adjourn okay
Lordship,
next week put it next week yes
okay.
117
And sometimes tomorrow, my lord. Only tomorrow, my lord. Tomorrow.
wait
I leave in space tomorrow, my lord. I also contact the client. Otherwise your lordship will PO after this.
day after tomorrow
Yes, sir.
yes next
118
I please your lordship.
yes.
Lordship, here the petitioner was convicted under section 324 IPC. 3-year RI and
3 years right
3 years RI and 1,000 rupees fine. He has undergone sentence of 22 days from 2016-2005 to 1911-2005.
then get ready put it next week huh
Well,
you tell me whether it's a case of acquittal or we can reduce the sentence
Lordship, we can reduce the sentence to 22 days, then that will be
undergone how much
22 days.
22 give me then I put it day after tomorrow
Yes.
just give a 1-page note
Yes.
so that I can
Lordship, only grounds are there, Lordship, the prosecution has not able to seize the alleged weapon of offense.
whatever you give 1-page note
Yes.
already undergone so that we will pass next
119
day after tomorrow huh? Get ready 19
119
that's super
119 also you can adjourn.
next week
120
done appear will be of justice adjourned to day after tomorrow
122
22
On behalf of H.S. Mishra, kindly to accept.
sorry
On behalf of H.S. Mishra, to accept.
22 you are for opposite party
No, I am for the opposite party, man. This matter, I am for the opposite
what
party.
is the opposite
My lord, this matter arises out of a 130 NI Act, my lord.
check amount
Check amount 90,000, my lord, since 2007, my lord. And conviction with regard to 6 months and compensation with 1,20,000, my lord.
you are the opposite party
Yes, ma'am. I am the complaint.
check amount is so less why don't you pay
Yes.
day after tomorrow 130 meter I will not keep it day after tomorrow
Oh, bless.
124
Let's say item number 124, I prefer an adjournment.
what is the offense start reading now next week
436 436 451 427 6 months 1,000 rupees per house. The motorcycle and the entire house has been set fire. That has been destroyed. The evidence of all the witnesses are corroborated to each other. There is no lacuna to discard the evidence of the prosecution. So at the end, it has been come to a conclusion that accused persons are convicted under section 436 of EBC. 6 months, 1,000 rupees fine. That is, if there is କିଛି custody ରେ ଅଛନ୍ତି ତାହେଲେ ସେଟା
Custody ଅଛି ନା
Verify from the LC.
ଆଚ୍ଛା,
Scan copy is there.
verify.
Judge may kindly allow us.
No. Responsible the petitioner seeks to inspect the LCR. LCR, let him do so. Leave the matter and so. Yes, next 25.
125, my lord. 25, my lord. Petitioner challenge the order passed in criminal appeal, my lord. The appeal is partly allowed. The conviction made by the trial court is under section 307, 506, 379, 447, 34 IPC. And the 307, the sentence period is 1 year. And the 6 months for the offense 506. And for 1 year for.
What is your case? You think you will be acquitted?
My lord.
Good case.
Not made out, my lord. 307 is not, I think not made out.
307 is not made out.
Not made out. Yeah, last item.
125, last item.
125 না?
20.
দফা 307 টা কেবল আছে, 447 টা আছে 1 month.
379, 447 IPC রে 1 year conviction.
That is acquittal.
447 রে 1 month conviction.
1 month. Only custody near to 4 months. And now 447 is not required. Only 307. Only custody in 3 months, 15 days. That is near to 4 months. And the dispute is for 307. My submission that 307 not made out. That's a that is land dispute between the informant and the petitioners. And their case is in RP case is pending.
What we'll do is we reduce the sentence to 6 months.
My lord.
Reduce the sentence to 6 months. 307. Mr. Maharaj?
Yes.
Is it possible? 307.
379, sir. 379 now. 307 acquittal.
307 put on him.
Sorry, because 379 but I'm questioning for 379.
You are saying 307.
Already ଅଛି ଆଜ୍ଞା 379, 447 IPC. 379 and 447.
47.
1 year. ଗୋଟା ହଉଛି 1 year, ଗୋଟା ହେଲା 1 month.
1 year କାହିଁରେ?
1 year
379 ରେ କରିଛନ୍ତି.
379.
Yes.
ତାକୁ reduce କରି କର।
ସେଟା reduce କରିଦେଲେ କହୁନାହାନ୍ତି କେତେ period cost।
4 ମାସ ହେଲାଣି।
4 ମାସ 6 ମାସ କରିଦା କାମ ଖାତା।
2 ମାସ ବାପା ପୁଅ land dispute ଥିଲା ଆଜ୍ଞା। ତାକୁ civil court favor order କଲା। Civil court ମୋ favor order କଲା।
Judgment reserved. See, 4 months you have already undergone. Remission, everything will be counted. You will go for 10 days, visit the jail and come back. What is the problem?
This